Cool. All right. Any disputes arising out of this competition must be reported in accordance with the competition rules. Compliance with time requirements will be considered in scoring individual performances. All right, so at this time, I would like the leader of each team to introduce participating team members.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Olivia Longi, and today I will be conducting the direct examination of Carson Durst, the cross-examination of Blake Doncourt, as well as delivering the opening statement on behalf of the plaintiff.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Charlotte Combe, and today I will be conducting the direct examination of Dr. Casey Rogers alongside the cross-examination of Skylar Weirs.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Jordan Ryan, and today I'll be conducting the direct examination of Dakota Weirs, the cross-examination of Devin Williams, and presenting closing arguments on behalf of the plaintiff. At this time, may our witnesses please introduce themselves?
Yes, please. Welcome, Ms. Ryan. And before we do that, the very first person, pronounce your last name for me. Olivia?
Yes, of course, Your Honor. It's Longi.
Longi, thank you very much. Okay, go ahead with your witnesses.
Good morning, Your Honor, members of the jury. My name is Milo Lamas, and today I am Dakota Weirs.
Good morning, Your Honor, members of the jury. My name is Lily Radowski, and today I am Carson Durst.
Good morning, Ms. Radowski.
Good morning, Your Honor, members of the jury. My name is Harriet Falconetti, and today I am Dr. Casey Rogers.
Good morning and welcome. All right. Who's next?
May the defense introduce themselves, Your Honor?
Yes, please.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Leah Dino, and today I will be conducting the direct examination of Skylar Weirs, the cross-examination of Dakota Weirs, and delivering the closing argument. At this time, may my co-counsel please introduce themselves?
Yes, welcome, Ms. Dino, please.
Good morning. My name is Carmela Carboni, and I'll be conducting the direct examination of Blake Doncourt and the cross-examination of Carson Durst.
Good morning.
Good afternoon. My name is Andrew Markle. I will be conducting the direct examination of Dr. Devin Williams, the cross-examination of Casey Rogers, as well as delivering the opening statement. At this time, may the defense witnesses please introduce themselves.
Yes, please, Mr. Markle.
Good morning. My name is Maisie Bogich, and I am Skylar Weirs.
Welcome.
Good morning. My name is Dirksen Brinkerhoff, and I am Devin Williams.
Welcome.
Good morning. My name is Grace Hoyt, and I am Blake Doncourt.
Welcome, Ms. Hoyt. All right. All right, let me swear in start with the team members. Please raise your right hands. Do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
I do.
Are there any no's? All right. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and the procedures of the mock trial competition? Any no's? All right, so far so good. To the extent there are any gallery members, teachers, coaches, or anybody like that, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? Outstanding, thank you. And of course, scoring panelists, Ms. Cap, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I did.
Outstanding. Thank you all. All right. I am going to try to be assiduous in remembering to take some time after each person. Let me ask the scoring judges, do you want me to wait for each round or after each witness to give you a moment to score? Bill?
My own opinion, if there's a quick moment in between each stage, so in between openings and witnesses, and then in between each witness, that would be helpful because that's just the way the score sheet's laid out.
Good, fantastic. That's what we'll do. All right. All right, so let's get started. Are there any preliminary matters?
Yes, Your Honor. The plaintiff has a few preliminary matters.
Okay.
First, we'd like to ask your permission to screen share exhibits constructively outside the eyes of the jury for purposes of authentication before they've been admitted, as is allowed under Rule 7.4 of the Rules of Competition.
Any objection from the other side?
No objection, Your Honor.
All right, that's granted.
Your Honor, we'd also like your permission to be able to use Zoom features to mark up or annotate exhibits once they have been entered into evidence, as also allowed under Rule 7.4.
Defense?
No objection.
All right, we'll do that as well. We would do it slightly differently in court, but that works for me.
Next, Your Honor, we'd like to ask your preference. If an objection is sustained, would you prefer that we move to strike testimony or consider that testimony stricken from the record?
That's a great question. We'll consider it stricken just in the interest of time and because we have a sophisticated jury.
And lastly, Your Honor, if at any point the court cannot see or hear a witness or lawyer presenting, we ask that the court may intervene so that we might fix that problem.
I'll scream. Thank you.
Thank you, Your Honor. At this point, the plaintiff is ready to proceed.
All right, thank you. Ms. Dino?
Just one preliminary matter. We ask that the jury is constructively given jury instructions before closing arguments begin.
That will be fine, because of course that would happen. All right. All right, let's start with openings, please. Is everybody ready? Anybody need a moment? I'll tell you what, let's take 2 minutes in case anybody needs to use the restroom, frankly. And we'll take a moment if anybody needs to do that, and then we'll get jumping. Because otherwise it's a slog.
Thank you, Your Honor. That gives me a moment to adjust my camera.
And I can let my dog out.
The judge,
Yes.
did you want the scoring panelists on during opening and closing or off the entire time?
On during openings and closings. Thanks for
Okay.
asking.
Thank you.
Your Honor, the plaintiff is ready to proceed with openings when you are.
Good. Let me make sure everybody's here. Can we go to a different view here? All right. I'm afraid somebody hasn't shown back up yet. Everybody who can, please turn your cameras on for a moment. That way I can get a sense of who's not here. All right. Thanks for being patient with the old guy. Let's do this. All right, counsel.
Proceed, Your Honor. They knew the risk. They sold it anyway. Dakota Weirs was a young, involved member of his community. He was an excellent student and an amazing musician. He played the piano. And this talent had even earned him a scholarship to Juilliard, his dream school, until it was all ripped away. And Dakota was diagnosed with non-Hodgkin's lymphoma, a type of cancer. However, this diagnosis was no accident. It was not bad luck. Today, you will hear exactly what caused Mr. Weir's cancer, and you will hear that it was Lush Fertilizer and their product, Drufo, because they knew the risk and they sold it anyway. We, the plaintiff, have sued Lush Fertilizer for negligence on behalf of Dakota Weirs. That means that we carry the burden of proof. We must prove to you by a preponderance of the evidence, which means more likely than not. Three things. 1, Drufo causes cancer, and Lush was aware of this. They did nothing to stop this risk. And this chemical has caused Mr. Weir's cancer. All because Lush Fertilizer knew the risk and they sold it anyway. Let's talk about those 3 points. 1, Drufo causes cancer. Today, you're going to hear from Dr. Casey Rogers, a scientist who has run experiments on Drufo. Dr. Rogers is going to tell you about a test that she did that showed frequent users of Drufo were 10 times more likely to be diagnosed with cancer than those who did not use Drufo. 2, Lush knew about this risk. Today, you're going to hear from Miss Carson Durst. Miss Durst is going to tell you about a study, a meeting, and an email, all of which discussed Drufo causing cancer. She's going to tell you that Lush knew or should have known about this risk. She's going to tell you that they ignored it. Lush could have done something to prevent this risk. Today, you're going to hear from Miss Blake Doncourt, the CEO of Lush herself. Miss Doncourt is going to tell you about a simple manufacturing process called baking, a step that could have been taken to eliminate any risk that Drufo would cause cancer. And Miss Doncourt is going to tell you that she made the decision not to bake Drufo because it was just too expensive. At the end of today's trial, my co-counsel, Jordan Ryan, is going to ask you for some damages for the physical and emotional suffering that Dakota Weirs has endured. Because Lush Fertilizer knew the risk and they sold it anyway. Find them liable. Thank you.
Thank you, counsel. Hang on just a moment. Give our judges a moment. All right. First witness, please.
Your Honor, will the...
Oh, I'm sorry. I'm sorry. Jeez. I'm anxious to go. Pardon me. Go ahead, Mr. Markle. I appreciate it.
Good morning. My name is Andrew Markle, and along with my co-counsel, I represent the defendant, Lush Fertilizer. The story you just heard is a sad one. It's tragic when anyone gets cancer, particularly someone as young as Dakota Weirs. But plaintiff's counsel didn't tell you the whole story. This is a case about Dakota Weirs trying to find a defendant with the deepest pockets. The plaintiff claims Lush Fertilizer was negligent in failing to warn users about the dangers of Drufo, a bonding agent in its fertilizers. They must prove their allegations by a preponderance of the evidence, which simply means more likely than not. The plaintiff will not be able to meet that burden. The evidence will show Lush didn't and couldn't know that Drufo was harmful to humans because it isn't. Lush Fertilizer was formed in 2000 by Blake Doncourt. Mr. Doncourt will testify about how hard he worked to turn Lush into one of the largest fertilizer suppliers in the world. She will tell you about the company's charitable contributions and the profits she created. Drufo is a revolutionary chemical that actually decreases the amount of fertilizers that has to be applied. Less fertilizer means less nitrogen, which is good for the environment and, more importantly, for people. Drufo is also an effective pesticide, which means other chemicals which are known carcinogens don't have to be added. You will hear Lush did extensive research and conducted studies on the safety of Drufo. You will hear more about those studies from Dr. Devin Williams, the head of Lush's research and development labs. He will tell you that there is no valid evidence establishing a causal link between Drufo and cancer. Finally, the defense will call Skylar Weirs, the plaintiff's twin sister. She is an investigative journalist and conducted significant research about potential risks of Drufo. She could not locate any study that established with any level of certainty that Drufo causes cancer. You will hear that even though she's testifying against her sister, she believes she must stand up for the truth. Dakota Weirs will testify about their summer job at a local company called Haven Landscaping. He will admit that Haven Landscaping did not take necessary precautions in order to protect their employees. Haven let a 14-year-old boy work with pesticides and fertilizers and allowed its employees to ignore the rules about protective clothing. So why isn't Haven being sued? The evidence will show Haven is a small local company while Lush makes millions of dollars. That isn't the only ulterior motive in this case. Plaintiff will also call Carson Durst. You'll hear she is a disgruntled former employee and a former family friend of the Doncourts with an axe to grind. She was fired for poor performance and left to work for Lush's competitor. Although she will try to suggest otherwise, she has no personal knowledge of any studies showing a statistically increased risk of cancer in humans from exposure to Drufo. The plaintiff will call Casey Rogers as an expert. Dr. Rogers will admit she wants you to favor the plaintiff because that may mean more lawsuits, and more lawsuits mean more opportunities for her to be hired. In the study that Dr. Rogers conducted lacks substance. She compared users of fertilizers to non-users, but failed to measure any risks specific to Drufo. Although there is no evidence showing a statistically significant risk of cancer from Drufo, Lush still took precautions to keep its customers safe. You will see that Lush put a warning label on its products recommending that users wear a mask and protective clothing, like long sleeves and pants. Reasonable, simple precautions. The problem is that Dakota ignored this warning. Dakota Weirs will admit that he was supposed to use protective clothing and a mask, but he didn't want to. He ignored the recommendations as he thought it was too hot to wear long sleeves. It may be uncomfortable to put blame on someone who is sick, but the evidence will show the plaintiff did not act reasonably. At the end of this case, the court will instruct you about the law you must apply. You will hear the plaintiff must prove by a preponderance of the evidence that Lush failed to act reasonably and take reasonable care to warn its users. The evidence will show that Lush acted reasonably at every step based on science available to it. Dakota Weirs and Haven Landscaping did not. At the end of the evidence presented, we ask that the jury find in favor of the defendant. Thank you.
Give our judges another brief moment. All right. Now we're ready for our first witness.
Yes, Your Honor. The plaintiff calls Dakota Weirs to the stand.
All right.
Please introduce yourself to the jury.
Let's swear the witness first. You solemnly swear or affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. Please introduce yourself to the scoring panelists.
My name is Dakota Weirs.
Why are you here today, Mr. Weirs?
I recently received a diagnosis.
What was the diagnosis you received?
Non-Hodgkin lymphoma.
I'm very sorry to hear that, Mr. Weirs. I'm going to have to ask you some questions about it. What exactly is non-Hodgkin lymphoma?
Well, I'm no STEM kid, but it's a cancer.
Mr. Weirs, we'll come back to that a little bit more later, but right now I'd like to talk to you about what might have caused your cancer. Are you familiar with Lush fertilizer?
I am, yes.
Why are you familiar with Lush fertilizer?
I worked with it back in my landscaping job.
As a landscaper, what company did you work for?
I worked for Havens Landscaping.
And how long were you a landscaper at Havens?
Let's see, I joined back when I was 16, 14, so a couple of years.
And what was your main job as a landscaper?
Well, I was hired to spread fertilizer and different chemicals.
Do you remember which fertilizers you used as a landscaper?
I mostly remember using Lush.
Would you recognize a picture of that packaging if you saw it?
I believe I would.
Ms. Bratich, if we could get Exhibit 1. Mr. Weirs, what do you see in Exhibit 1?
This appears to be Lush fertilizer packaging.
Is it a fair and accurate representation of the packaging you saw while working as a landscaper?
It is.
I apologize, Your Honor. I seem to be having a bit of technical difficulties.
Okay,
Can I-
we'll stop the clock for a moment. It's fine.
I apologize, Mr. Weirs. Could you tell me again, what do you see in Exhibit 1?
This appears to be the Lush fertilizer packaging.
I'm sorry, Your Honor. Could we pause time? I still can't hear Mr. Weirs.
Yes, please. Let's take a moment. Do whatever you need to do, Ms. Ryan.
May I switch computers with one of my co-counsels if that's all right with you?
You may.
Sorry about that, Your Honor.
That's all right,
Thank
no
you
problem.
for Working with me.
Everything looking okay?
Yes, I just had a technical malfunction.
All right, good. All right, let's, as soon as you, let's see, there's 22:31 left for the plaintiff, 22 minutes, 31 seconds left, and we'll start the clock now,
Thank you, Your Honor.
Ms. Ryan.
Mr. Weirs, what's an Exhibit 1?
Exhibit 1 is a copy of Lush Fertilizers packaging.
And is it a fair and accurate copy?
It is, yes.
Your Honor, at this time, the plaintiff moves to admit Exhibit 1 into evidence.
Yes, any objection to Exhibit 1?
No objection, Your Honor.
All right, so Exhibit 1 will be admitted. Ms. Longi, if you could move slightly closer to your computer or have your computer moved a little bit closer to you, that might be helpful. Fantastic, thank you.
Your Honor, just for clarification, I'm Jordan Ryan. I switched computers.
Ms. Ryan, I'm sorry. Thank you.
Mr. Weirs, could you highlight what are the ingredients in Lush Fertilizer?
For sure. Let's see here. We have nitrogen, phosphorus, and Drufo.
Mr. Weirs, could you also highlight what are the safety warnings on this label?
Well, there are no warnings.
Are there warnings that say Lush Fertilizer could give you cancer?
No, none.
Does this label warn that Lush Fertilizer could give you non-Hodgkin lymphoma?
It does not, no.
So, Mr. Weirs, if there aren't any warnings on here, what does it even say?
It says what they all say. Avoid getting it in your eyes and wash it out if it happens.
Objection, Your Honor. Lack of foundation and assumes facts, non-evidence. Mr. Weirs is referring to the other labels by saying that's what they all say, and we don't have those other labels and evidence and don't know what they say.
Ryan?
Your Honor, if you look in Exhibit 1 on the right side, it says, as with any spray fertilizer, that implies the normal recommendation on spray fertilizers as well. Mr. Weirs testified that he used multiple different types of fertilizers in his job and would therefore know what those recommendations were.
Do you have an offer of proof as to what the other testimony might be?
Your Honor, an offer of proof as to what the other labels say?
Correct.
Your Honor, I'm not specifically asking Mr. Weirs about what those other labels say, only
All
his knowledge in reference to what that label said, which.
All right. Last word, Ms. Dino.
Yes, Your Honor, an offer of proof cannot be given to what the other labels say because we do not have the labels of the other fertilizer products. I object to clarity to make sure that the jury knows that we do not have those labels here in court today, and Mr. Weirs cannot testify to the ingredients or the safety precautions on those labels.
All right, this would be a conversation we'd have outside of the presence of the jury. The objection is respectfully overruled.
Mr. Weirs, I'd like to come back and ask you a little bit about your diagnosis. How old were you when you were diagnosed with non-Hodgkin lymphoma?
I was 19 when I received my diagnosis. My life has been over since I even turned 20.
What was your life like in school before your diagnosis?
It was a great time. All AP classes. I was consistently involved in my school. I was school president. I had lots of friends. It was a great time.
What was your life like outside of school before your diagnosis?
Heck, it was even better. I was constantly involved in the community, different shelters, but mostly I did what I loved, and that was playing the piano.
Why was playing the piano so important to you?
Well, it's one of those things you can't quite pinpoint, but everyone important around me, my mother, my grandfather, my father, had always played the piano or been connected to it, and that had an effect on me, but it was all for naught.
Why do you say it was all for naught?
Well, with my condition, I developed constant aches and pains, and I can barely sit on the piano bench for any period of time. I can't even play my favorite concerto, Flight of the Bumblebees, anymore. It's just pure agony.
Mr. Weirs, were you intending to pursue a career in piano?
Objection, one moment, Your Honor. I am having a lot of trouble hearing Ms. Ryan, opposing counsel.
Yeah. See if you can move a little bit closer or adjust your sound. I know that this is a inconvenience for you, but let's see what we can do, Ms. Ryan.
Thank you.
Take a moment. We'll give you an extra 30 seconds.
All right, is that any better?
No.
All right, 1 second, Your Honor. I'm so sorry.
That's all right. That's all right. Don't worry about it. No
How
pressure.
about now?
That'll work. We'll just make it work.
All right, thank you.
Thank you, Ms. Dino. Go ahead.
Mr. Weirs, did you intend to pursue a career in playing the piano?
I did, yes. I had big plans.
What do you mean you had big plans?
Well, I got accepted into the Harvard of Music, Juilliard, with full ride, but on all my piano playing skills. But as I can't play the piano, I had to turn that down.
And Mr. Weirs, what other symptoms have you experienced as part of your diagnosis?
Well, aside from the constant aches and pains, I have swollen lymph nodes constantly. My abdomen sometimes swells to twice its size, and I'm always on the couch. I've had to resign myself to the extreme sport of knitting.
Mr. Weirs, so what has this diagnosis done to your life?
It's ruined my life. It's taken it all away.
And Mr. Weirs, what has this diagnosis done to your future?
It's torn it from my grasp and ripped it up in front of me. It's destroyed my future.
Thank you, Your Honor. I have no further questions. May I
Thank
have
you.
another few seconds to see if I could get my setup working again, if that's all right with Ms. Dino?
Sure. You want to do that right now?
I would love to, Your Honor.
Yes, let's do that.
Your Honor, do I sound okay over here?
That's fantastic. Thank you.
Thank you so much for
Well
understanding.
done. All
I'm
right.
ready to proceed.
All right. Are we ready for cross?
Yes, Your Honor.
All right.
Good morning, Mr. Weirs. I have a few questions for you. So while you were spreading the fertilizer at Haven Landscaping, you like to feel the wind in your face, right?
105-degree weather, who wouldn't?
Right, and you like to feel the wind in your eyes, right?
Sure.
You knew you were supposed to cover your face when working with harsh chemicals, right?
I mean, all the older guys around me didn't. I thought they knew best, but yeah.
And you chose not to wear protective gear, right?
I just followed what the others were doing. I thought they knew best.
Mr. Weirs, can you please turn your attention to Exhibit 1?
I don't have Exhibit 1 in front of me, but if you could screen share that.
Of course, Mr. Weirs. One moment, Your Honor. My opposing counsel is attempting to screen share. Mr. Weirs, let's look at the recommendations that are on this label. Read with me. It says, as with any spray fertilizer, utilize protective clothing that covers exposed skin. Do you read that?
I do see that, yes.
You didn't wear protective clothing that covered your exposed skin, did you?
Well, I mean, none of the older guys did, so no.
The label says use of a respirator or N95 mask is recommended. You didn't wear a respirator or N95 mask, did you?
If only I had known differently.
Finally, it says follow manufacturer's instructions for cleaning/maintaining personal protective equipment. Do you read that?
I do.
You didn't use any personal protective equipment, correct?
No, if only I knew.
Thank you. That'll be all for the screen share. Now, Mr. Weirs, you testified that other fertilizers and chemicals you use often had some sort of kind of warning on the packaging.
Yeah, recommendations or warnings, yeah.
And those warnings were put in place to help customers take precautions when using the product, correct?
Sure.
You didn't pay attention to those warnings either, did you?
I just followed what all the older people were doing. I thought they knew the best.
Ms. Weirs, you just testified that you were high achieving in high school, right?
I was, yes.
You got good grades.
I did.
Mr. Weirs, you had to have known that what you were doing was dangerous.
I mean, I was just following what all the older guys were doing. I mean, I thought they knew the best.
Well, let's talk about those older guys that you keep talking about. So you were 14 when you started working at Lush or Haven, correct?
That's correct.
And 14 was too young to work with the machinery, right?
Yeah.
It was too young to ride on the big lawnmowers, right?
Mm-hmm.
So these older guys, your bosses at Haven, allowed a 14-year-old boy to work with harsh chemicals when the lawnmowers were too dangerous for him?
I mean, after Bill cut his foot off with one of them, I mean, who could blame them?
Your bosses not only let you work with the harsh fertilizers, but they didn't require you to wear protective gear.
No, just recommendations.
You're not suing Haven today, are you?
No, my lawsuit is against Lush.
Right, you're not suing Haven because their pockets aren't deep enough for you.
That's okay, sure.
Now, I want to clear a few things up. On direct, you testified that you can't go to Juilliard because of your cancer.
Consistent aches and pains, I can't play. It's nearly impossible.
Right, but you can't go to Juilliard because you gave up that scholarship.
My full ride scholarship was for playing the piano, and I can't play the piano.
But you might be able to in the future, and that's why Juilliard deferred the scholarship for 2 years, didn't they?
This might be fatal for me. I don't know if I'll ever get better.
You say it might be fatal, but your doctors haven't given up hope, Mr. Weirs.
Well, you see, my doctor walks into my room wearing a clown costume. You can't expect me to take him seriously.
No doctor or other expert has ever opinionated that you're not going to get better, correct?
It's a harsh disease. There's not a bright chance of recovery.
That's your own belief, though, isn't it, Mr. Weirs? Not a doctor's.
It's a cancer.
You're just speculating that you're not going to get better right now.
I might have a chance, but it's minimal. There's not much of a chance.
In your own opinion, has any other doctor ever said there's not much of a chance of you getting better?
I only have one doctor, and although he might be optimistic, the science doesn't show.
Do you know that science, Mr. Weirs?
I don't have that science in front of me, but you know.
Mr. Weirs, you're suing Lush Fertilizer for emotional damages, correct?
I am. I've been caused severe pain by their product.
What's the exact amount you're suing for?
2.6 million.
Mr. Weirs, nowhere in your statement does it say that you looked into any possible environments that could have given you non-Hodgkin's lymphoma besides Haven.
It was the one that showed the most. It was the most probable.
But Haven Landscaping isn't the only place that could have exposed you to a carcinogenic environment, correct?
Objection, Your Honor, calls for speculation.
Response, Your Honor.
I'm sorry. Yes, please.
Worries, Your Honor. In Mr. Weirs' statement, he did research. He understands that the carcinogenic environments are could be multiple places. He does mention that he's suspecting that it happens at Haven, which is implied that he knows he could have caught it somewhere else.
Thank you. The objection's overruled.
I'm going to re-ask my question, Mr. Weirs. Haven Landscaping isn't the only place where you could have been exposed, correct?
I could be exposed anywhere. I mean, heck, a water bottle has a chance of getting cancer.
Yeah, exactly, Mr. Weirs. And even back at Haven, you weren't the only employee using Lush.
There were lots of employees, but it was the most probable place. A water bottle isn't very likely to give me cancer, but a product like Lush is.
You are the only employee ever diagnosed with non-Hodgkin's lymphoma at Haven, correct?
I've fallen out of contact with others, but I believe so.
At Haven, you worked with other chemicals, right?
Sure.
You didn't look into those other chemicals because you had already decided you were going to sue for Lush's deep pockets, correct?
I saw probable cause, and yeah.
You don't really know if Drufo is what caused your illness, do you?
I have a high degree of certainty, but I cannot be 100% sure.
You don't have a high degree of certainty because in your own words, you are suspecting that Drufo caused your illness, correct?
It seems pretty apparent to me that Drufo caused my illness.
No further questions, Your Honor.
All right, thank you. We'll give the judges a moment. All right, Ms. Ryan. You're right.
Mr. Weirs, on cross, you were asked a little more about what was in Exhibit 1. What wasn't included in the Lush label?
Well, there were no warnings telling me that I might develop cancer from their product. Nothing, just brash recommendations.
When you were using Lush fertilizer, did you have a reason to believe that it was going to give you non-Hodgkin lymphoma?
I had no reason if only I knew differently.
Mr. Weirs, you were also asked about exactly why you sued Lush Fertilizer. Did you choose to sue Lush Fertilizer because they had the most money that you could find?
Absolutely not. I sued them because they caused my illness.
Thank you, Your Honor. I have nothing further.
All right. Thank you, Ms. Ryan. Give the judges a moment to score. Okay. Next witness, please.
Yes, Your Honor. The plaintiff calls Carson Durst to the stand.
All right, Ms. Long. All right, good morning. Please raise your right hand. You solemnly swear or affirm that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. Please introduce yourself to the scoring panelists.
Hi, my name is Carson Durst.
Good morning, Ms. Durst. Could you please tell us a little bit about yourself?
All right, and let's get a little more sound, if possible.
How's this, Your Honor?
Fantastic, thank you.
Thank you for pointing that out. Please continue, Ms. Durst. Tell us about yourself.
I love doing this. Okay, so I'm the 3-time national Sudoku champion. If you ask me, I should have been the 4-time. I should have beaten Bobby Fischer back in 2014, but whatever.
Thanks for telling us about your Sudoku, Ms. Durst. What do you do for a living?
Well, I'm currently the lead product developer at Terrace Greenery. I find it's actually a lot like Sudoku. It's kind of filling in all the squares and lining up all the numbers to make a safe product. It's really cool.
Since you're involved in the agriculture industry, are you familiar with Lush Fertilizer?
I am. I used to work there.
When did you work there?
From 2003 to 2006, so for around 3 years.
And at Lush, what was your role?
While I was on the product development team, I looked into the safety of a product called Drufo.
What is Drufo?
Drufo is a chemical that Lush created. They put it into their fertilizers.
And when you were researching Drufo, what did you find?
Like I said, I was on the research and development team. When I was doing my research in early 2003, I came across a study that was done in Europe on one of the ingredients in Drufo, C3NO9P.
And would you recognize a copy of the study?
I would.
Do you know how old this study is, Ms. Durst?
I never specifically found a date of publishing, but I do know that I found it in early 2003, and the latest date cited in the study is 2002.
Your Honor, at this time, my co-counsel is going to share what has previously been marked as Exhibit 3.
All right.
Oh, Your Honor, you're muted.
All right, this will be constructively outside the.
Thank you, Your Honor. Now, Ms. Durst, what is this document?
This is the study that I just mentioned.
Is it a fair and accurate copy?
It is.
Your Honor, at this time, the plaintiff moves to enter Exhibit 3 into evidence.
Objection, Your Honor, hearsay.
Response, Your Honor. Your Honor, I am prepared to offer 2 arguments to this. My first is under Rule 803.16. This document is an ancient document and therefore an exception to hearsay.
Okay. What else?
My second argument would be that we are not offering this document for the truth of the matter. We're simply offering it to show knowledge.
All right. Is there a reply with respect to this objection?
Yes, Your Honor. Under Rule 803.16, this document is not old enough to be qualified as an ancient document. It has to be over or 20 years old or over, and there's no testimony that is for sure over 20 years old. And to the second matter, this is being used for the truth in the matter asserted, or it otherwise has no relevance. The plaintiff is trying to prove that the assertions in the secondary study are truthful and would meet their burden of proof to prove Drufo caused carcinogenic effects. The use of this document would be hearsay.
All
May I
right.
respond, Your Honor?
Briefly.
Your Honor, this document is an exception under the ancient documents. My witness has testified that dates found in this study are from 2001 and 2002, which would make this document at least 20 years old, therefore an exception to hearsay. In response to opposing counsel, We are not offering this for the truth of the matter, simply to show that Lush had knowledge.
All right, thank you. The objection's overruled. With respect to the ancient document exhibit, that may be, but the keystone of admissibility is reliability, and I don't think that the 20-year rule would apply. But I do think that it is not offered for the to prove the truth of the matter asserted, and I'm going to instruct the jury not to consider it for that purpose, but I believe it's being offered simply as the basis for the witness's understanding of the information contained in it.
Thank you, Your Honor. May we consider this constructively published to the jury?
We certainly can.
Now, Ms. Durst, if you could take a little bit of a closer look at this document, and in the third column, would you mind reading that sentence?
Yeah, under the results column, it says, our results show a statistically significant dose-related increase of malignant tumor-bearing animals, particularly in the group treated with 2,000 parts per million C3N09P, and an increase in incidence of lymphomas and leukemias.
That's a very complicated sentence, Ms. Durst. Would you mind putting it in simpler terms for the jury?
Yeah, so basically what this study is saying, when the rats, which were the subject of the study, were given higher doses of C3N09P, an ingredient in Drufo, they had a much higher chance of developing cancer, specifically lymphoma and leukemia.
Now, Ms. Durst, when you found this study, what did you do with it?
Well, all of the members of the research and development team had a research notebook, and I recorded the findings of the study in mine.
Is there a standard procedure for your notebook?
There is. Like I said, all of the members of the research and development team had one, and our project manager, Jerry Langley, would always look them over and submit her findings to upper management.
Objections.
Now this,
Your Honor.
Oh, hang on, wait for the objection. Go ahead, counsel.
Speculation, Your Honor.
Response?
yes, Your Honor. My witness has testified that she worked at Lush and was involved in the research and development. Therefore, she would have knowledge of what went on with her findings and therefore the company notebook that she entered these findings into.
Ms. Carbone?
Yes, Your Honor, there has been no foundation laid that Jerry Langley has actually saw the journal, and they're simply speculating of what Jerry Langley saw.
May I respond, Your Honor?
You may not. The objection, although well-founded, is overruled.
Thank you, Your Honor. And now, Ms. Durst, besides this study, were there any other discussions about Drufo causing cancer?
Well, one of the things that jumps out to me is a meeting in December of 2003.
Who attended this meeting?
Myself, other members of the research and development team, and one of the higher ups in the company, Alex Monroe.
What was discussed at this meeting?
Well, it was about the safety of Drufo and about all of our findings during our research. And one of the scientists expressed her concerns that Drufo could cause cancer, specifically non-Hodgkin lymphoma.
And how was this information received?
Well, like I said, Alex Monroe, one of the higher ups, was there, and he said something that actually really bothered me. I honestly kind of found it disturbing.
What did he say, Ms. Durst?
He said, let's just keep this in the walls until we figure out what's going on.
Now, after both the study and the meeting, were any other discussions brought up at Lush?
Your Honor.
Yes, I'm sorry, Ms. Carbone, I didn't hear you.
I was trying to make an objection to the prior question that it was hearsay.
And remind me what the question was and what the answer was.
That
yes, sir.
Go ahead, Ms. Carbone.
That Alex Monroe and what was discussed.
All right. Ms. Lange?
Yes, Your Honor. Alex Monroe is a part of Lush, and therefore this is not hearsay as it falls under a statement of a party opponent under Rule 801 D2D.
Ms. Carbone?
Under 801 D2, the foundation has not been laid for this person to speak on the company's behalf and is therefore hearsay.
May I respond, Your Honor?
Briefly.
801 D2D states that any person speaking within the interest of their employment or their company is considered a statement of a party opponent. Alex Monroe was speaking in the interest of his company, Lush, and therefore this is a statement of a party opponent.
The objection is overruled. I find that it's not offered to prove the truth of the matter asserted.
Thank you, Your Honor. And now, Ms. Durst, after both the study and the meeting, were there any other discussions at Lush?
There was. There was an email that circulated in September of 2003.
And who sent this email?
My project manager, Jerry Langley, did.
If I could please have my co-counsel screen, my apologies. Would you recognize a copy of this, Ms. Durst?
I would.
Now, Ms. Durst, the document on the screen, what is that?
This is the email that I just mentioned.
And is it a fair and accurate copy?
It is.
Your Honor, at this time, the plaintiff moves to admit Exhibit 4 into evidence.
All right, is there any objection to Exhibit 4?
Yes, Your Honor. Authenticity, hearsay, and in addition, the publication of this document would violate a confidentiality agreement between Carson Durst and Lush Fertilizer.
Okay. Response?
Yes, Your Honor. In response to the authenticity question of this email, my witness has testified that she received this email and it was sent from her product manager at Lush. Under Rule 104, we have met all of the authenticity requirements and therefore this should be admitted.
All right, the authenticity objection is overruled. Let's hear about hearsay.
In response to hearsay, Your Honor, under Rule 801 D2D, this was sent from Jerry Langley, therefore a person who is employed by Lush, which therefore makes it a statement of a party opponent.
All right, and therefore not hearsay. All right, Ms. Carbone?
To the hearsay response?
Correct.
This document is being used for the truth of the matter asserted. Plaintiff is clearly discussing the contents of the email to show that they are true. It is not relevant if it is not being used for the truth of the matter asserted. Mr. Simply receiving an email has no relevance.
May I respond, Your Honor?
Briefly, I know I'm worried about your time for you guys, but go ahead.
Thank you, Your Honor. We are not using this for the truth of the matter. Again, we are simply using it to show knowledge of Lush.
All right, the hearsay objection is overruled and the scoring panelists are directed not to consider this for the truth of it, but rather for the reasons set forth by Ms. Longi. What about the confidentiality agreement?
Yes, Your Honor. In regards to the confidentiality agreement, that is a topic that opposing counsel is welcome to bring up on cross. However, it is also a different subject from what we are discussing here today. We are discussing whether or not Drufo has caused Mr. Weir's cancer. The fact that Ms. Durst is violating a confidentiality agreement is a separate argument for a separate time.
Thank you. Response?
Yes, Your Honor. May I make an offer of proof?
You may.
This exhibit is to be protected by a non-disclosure covenant, paragraph 2 of Exhibit 5, signed by Ms. Durst before this email was made. There's no time limit on this prohibition. The email in this question contains finances and plans of the patented chemical Drufo. Ms. Durst had no right to produce this email.
All right, the confidentiality agreement argument is strenuously overruled. One cannot privately agree to keep information out of a courtroom. Trials are searches for truth, and one can't hide for corporate benefit the truth of a case from a court. You can do it for other purposes, but the confidentiality objection is overruled as well, and the exhibit is admitted.
Thank you, Your Honor.
Thank you.
And now, Ms. Durst, if you could take a look at the second paragraph, would you mind reading that first line aloud for us?
Following our lab's June Drufo study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year.
Now, Mr. Durst, are there any names on the to line that stand out to you?
Well, there's myself, Carson Durst, Alex Monroe, and Blake Doncourt.
And now, Mr. Durst, after the study, the meeting, and the email, what did Lush do with all of this information?
Well, in the final report that came out on the study, there was no mention of any potential carcinogenic qualities at all. I mean, I found this to be really odd.
Why did you find this odd, Ms. Durst?
I mean, it was inconsistent with everything that I'd seen. I mean, the email, the meeting, the rat study, there was just no mention of it.
If the study didn't mention Drufo causing cancer, what did it mention?
Well, there was a recommendation for a process called baking.
What is baking?
Well, according to the study, baking is a manufacturing step where you apply a lot of heat to the product. It said that it could get rid of any risk of Drufo causing cancer at all.
Now, Ms. Durst, to your knowledge, did Lush ever bake Drufo?
No, they never did.
Thank you, Your Honor. I have nothing further.
All right, thank you. I'll let the judges score. I'm going to amend my ruling on that and say that Exhibit 4, rather than it being an exception to the hearsay rule, that it's not hearsay, because I think that the testimony was to the truth of the matter asserted. But that's for what that's worth.
Thank you, Your Honor.
All right.
I appreciate that.
All right. Is there cross-examination? Is it Carbone or Carboni?
Carboni, Your Honor.
Carboni, I apologize. All right, go ahead.
Good morning, Ms. Durst. After
morning.
Blank pulled some strings for you to get this job as an intern, you assumed you didn't have to work as hard as everyone else, right?
No, that's not true at all.
You got lazy with your work.
No,
You started receiving bad performance reviews.
I did, but those coincidentally started cropping up about the same time I was bringing my concerns to upper management.
Well, once you complained to Miss Doncourt, she wasn't very sympathetic, was she?
No, she wasn't. Honestly, I expected her to stick up for me because of the obvious scapegoating that was going on, but I guess she didn't.
And that made you angry, didn't it?
It did at the time, but this was 15 years ago.
You felt betrayed.
I did. I thought that someone who I considered a friend would stick up for me while my coworkers and her company was lying about me.
You were later fired from Lush
I was.
in December 2006.
Yes.
But isn't it true that you already applied to Terra in 2005, almost 2 years before you were fired?
Well, not quite 2 years before I was fired, but I did apply because I saw that Lush was ignoring my concerns and not making a safe product, and I wanted to work for a company that did.
You thought applying at Terra would get Blake scoped, didn't you?
Yes, I did.
And that's why you did it, to get back at Miss Doncourt.
No, not specifically. Like I said, I wanted to work for a company that would hear my concerns and actually make a safe product.
Your Honor, permission to show opposing counsel for identification was previously been marked as Exhibit 5.
Request is granted.
Ms. Durst, what is Exhibit 5?
Exhibit 5, it appears to be a copy of the non-compete agreement.
And is this your signature at the bottom of the exhibit?
It appears to be, yes.
Is this a true and accurate copy of the agreement you signed?
I believe it is.
Your Honor, defense offers Exhibit 5.
What's the response with respect to Exhibit 5?
Yes, Your Honor. In response to Exhibit 5, you yourself have previously ruled that the non-disclosure agreement cannot be regarded in this testimony as it has no bearing in today's case.
What is, notwithstanding my prior ruling, what other argument do you have in opposition to Exhibit 5?
Your Honor, I would object relevance.
Ms. Carboni, what's your response to the relevance objection?
This document shows Ms. Durst agreed to keep certain things confidential in this contract. It is also relevant to the admissibility and authenticity of Exhibit 4, even though it has previously been admitted. It goes to the weight the jury should give the exhibit.
May I respond, Your Honor?
You may briefly.
Your Honor, the fact that this document shows Ms. Durst has violated an agreement has no weight in today's trial, as Ms. Durst cannot legally keep things out of court and she must tell the truth. The fact that this exhibit is being entered should have no bearing on today's trial.
All right. The relevancy of this is marginal, but I'm going to overrule the objection and allow the jurors to consider it for what it's worth.
Thank you, Your Honor.
Ms. Durst, please look at paragraph 2. Yes, paragraph 2. The employee will not at any time or in any manner, either directly or indirectly, divulge, disclose, reveal, or communicate any trade secret belonging to Lush to any third party, including but not limited to any competitor of Lush. Did I read that correctly?
You did.
You breached this contract, didn't you?
I mean, I don't really see what this has to do with Drufo causing cancer, but not specifically. I mean, we reached an agreement with Lush Fertilizer and Terrace Greenery.
Well, let's look at this. Can we please look at Exhibit 4? This is an email you claim to have received when you were employed at Lush, correct?
Yes, I did receive it.
But you don't work for Lush now, do you?
No, not anymore.
You have no knowledge of what documents are on Lush's email server.
I mean, no, not specifically, but I do know that I received this email from them.
Well, assuming this email is authentic, it deals with the development of Drufo, correct?
It deals with the safety of Drufo, yes.
And Drufo is patented, isn't it?
I believe so.
This email contains highly confidential information, right?
I would say so, but I don't really see how that's relevant to today.
You know this was a violation of your contract by producing this email.
I guess so, but I mean, I don't think it really matters. I mean, if Drufo wasn't safe, then that outweighs any confidentiality agreement that I may have signed with them.
Your Honor, at this time, the defense renews its objection to Exhibit 4, and we move to strike all of it in Ms. Durst's testimony relating to it.
That's denied.
Ms. Langley says in this email you say you received that a study was going to be performed on Drufo, right?
Yes, it says we need to reinitiate the study based on the carcinogenic findings.
But you have no personal knowledge about what the data from the second study showed, do you?
No, I only know about the first study.
During your research, you never found any study involving Drufo in humans, correct?
Well, not during my research. I found a study on rats and then Lush conducted their own study on humans.
And as you sit here today, you cannot point to any scientific study showing a connection to exposure to Drufo in humans and cancer.
Well, I would disagree. Although the study wasn't specifically done on humans, it was done on rats and it caused cancer. I mean, it biologically mutated the DNA. That's not a fluke.
You cannot show a connection between exposure to Drufo in humans and cancer.
Well, I have no study to that effect, but there is a connection based on the rat study.
No further questions, Your Honor.
Just a moment. All right, Ms. Lange, redirect.
Yes, Your Honor, briefly. Now, Ms. Durst, you were asked to cross a little bit about your poor performance reviews. When did those become an issue?
Like I said, they started happening right around the time that I started bringing my concerns about Drufo to upper management.
And Ms. Durst, you were also asked about your relationship with Blake Doncourt. Did that affect at all your decision to work for Terrace Greenery?
I mean, not really. My decision had pretty much everything to do with the fact that Lush was ignoring my concerns about Drufo. They weren't making a safe fertilizer. They weren't lining up all of the Sudoku squares.
And finally, Ms. Durst, how does your non-disclosure agreement affect you in today's trial?
It really doesn't.
Thank you, Your Honor. I have no further questions.
Excellent, thank you. Give our judges a moment. All right, next witness, please.
Yes, Your Honor. The plaintiff calls Dr. Casey Rogers to the stand.
All right, doctor.
Before I begin, can the court see and hear me all right?
Yes, thanks for asking. You pronounce your name Combe?
Yes, Your Honor.
Good, sorry about that. I'm 0 for 3, so I thought we would ask him again. Are you ready?
Yes, Your Honor, we're ready to proceed if you
Go
are.
ahead, Ms. Combe. You ask the witness to raise his right hand. His or her? I'm not seeing the witness. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, good. Thank you.
Good morning, Miss Rogers. Could you please introduce yourself to the jury?
My name is Dr. Casey Rogers.
And what do you do for a living, Dr. Rogers?
Right now, I'm a professor of horticulture and entomology at the University of California. And as a kind of side gig, I'm also a contractor for doomsday bunkers.
All right, Dr. Rogers, we'll talk more about your experience in education in a moment. But for now, do you know what Drufo is?
Of course.
Have you ever conducted any research on Drufo?
Yeah, I've done extensive research on Drufo.
Dr. Rogers, what formal education do you have?
Well, I got my bachelor's in agriculture and chemistry from Colorado State University. And after that, I went on to get my PhD in agriculture and entomology from the University of California.
Hang on just a moment. Thank you.
Dr. Rogers, you mentioned earlier that you've done research on Drufo. What typical areas of research interest you?
Well, for me personally, I like to examine the long-term effects of chemicals on the human body. I care a lot about people and keeping them safe.
Has any of your research been published before?
Yeah, I've been published in The Environmentalist before, as well as Weed Biology. And you can also read my weekly op-ed in Bunker Builders magazine.
Does any of your published research have something to do with Drufo?
Yeah, I think I've done about 4 studies on Drufo now. I suppose the most relevant one would be one that I did back in 2017 on Drufo toxicity and carcinogenicity.
Your Honor, at this time, the plaintiff moves to enter Dr. Casey Rogers as an expert in the impacts of toxicants on the human body.
Tell me again the impact of toxicants
on the human body.
Any objection or voir dire?
May I voir dire, Your Honor?
Yes, Mr. Mark, you may.
Dr. Rogers, you are not a cancer specialist, are you?
Well, I've worked tangentially with cancer before, but diagnosing, treating, that's not my job.
So you are not a cancer specialist, correct?
Not in a medical sense, no.
And you've never been to medical school?
That's not my job, no.
And you've never worked in a hospital, correct?
No.
You've never had any education or training in diseases of the lymph system, right?
Not formally, no.
You've never had any education or training in the treatment of cancer, correct?
Like I said, I look at the causes. The treatment isn't my responsibility.
Your Honor, we don't have an objection to Dr. Rogers' admission as an expert in the long-term effects of toxicants on the human body, but we do ask for a limiting instruction on medical testimony or opinions. Due to Dr. Rogers' witness statement, we have concerns that Dr. Rogers will attempt to testify to the mechanisms of non-Hodgkin's lymphoma, the symptoms, the survival rate, the treatment, or the diagnosis. And under Rule 702, an expert needs sufficient education or training in order to give expert opinions. And Dr. Rogers admits to not having any medical education, training, or employment, and so does not fit the qualifications of being able to give medical testimony.
So no, you're saying no training, education, or experience?
Correct, Your Honor.
All right. Response?
Yes, Your Honor. If I may make a brief offer of proof.
Yes, please.
Dr. Casey Rogers will not be testifying today to or specifically diagnosing any one individual with cancer or non-Hodgkin's lymphoma, as she is not a medical doctor, as she previously testified during the voir dire. However, her testimony about the causes and the impact of non-Hodgkin's lymphoma biologically on the body are well within the tendering of the effects of toxicants within the human body, as those are biological processes in the causes of those diseases, which she studies directly with her research in Drufo.
Mark, I'll give you the last word.
Yes, Your Honor. Well, Dr. Rogers is a scientist. She is not a medical doctor. And we have no objection to her testifying to her studies and anything regarding her studies affecting people. But we do ask that any medical testimony, as a scientist, she does not have the proper education or training to testify to any medical testimony, including symptoms or survival rate, diagnoses, treatment, or mechanisms of any type of cancer or non-Hodgkin's lymphoma specifically.
All right. I'm going to let the witness will be deemed an expert in the impact of toxicants on the human body. She can testify to her studies and to causes, but not symptoms, survival rates, or diagnoses.
Yes, Your Honor. Dr. Rogers, you mentioned that you've done research on Drufo and that you've even published some. Why?
Well, this is a bit of an explanation, but the end of the world, it doesn't all have to be doom and gloom. I am a heavy advocate for keeping a garden in your bunker. But of course, you need products to keep that garden safe, and you want those products to be safe for you. So that's why it concerned me when I saw that Drufo was carcinogenic in rats, because that's one product I had been considering.
So what did you do?
I put together a study.
All right. How was this study designed?
Well, we had 3 groups. We had a control group, people who had never used Drufo before. We had a group of people who occasionally used Drufo. And then we had a 3rd group of heavy, consistent users of Drufo, people who used it almost daily.
So with those 3 different groups in your study, what were the conclusions?
We found a serious uptick in medical conditions in those people who used Drufo.
Was there an uptick in any certain type of health condition?
Yeah, we saw a lot of cancers, including non-Hodgkin's lymphoma.
Could you briefly tell the jury what is non-Hodgkin's lymphoma?
I suppose in layman's terms, It's a cancer of the lymphocytes, the white blood cells.
Was there any correlation between a person's exposure to Drufo and the likelihood that they would develop those health conditions?
Yeah, after we put all the data together, we found that those people who occasionally used Drufo were 5 times more likely to contract cancer, and those people who consistently used Drufo were 10 times more likely.
Right.
I don't want to sound like a NIMB, not in my bunker, but Drufo is off my list.
All right, Dr. Rogers. I want to shift gears now and talk about Dakota Weers. What do you know about him?
Well, I've had the chance to review Mr. Weers' employment records. I know that he was employed at a landscaping company for a number of years.
So based off of the knowledge you gained from those employment records, what did you conclude about him?
Well, I'll put it this way. If I were to put Dakota Weers in my study, he would be in the heavy, consistent users of Drufo.
Finally, Dr. Rogers, after all of your research and the studies that you've conducted yourself on Drufo, what do you conclude about it?
Drufo causes cancer.
Thank you, Dr. Rogers. Your Honor, I have no further questions at this time.
Thank you. Give our judges a moment. Yeah. All right. Mr. Markle? Whenever you're ready.
Yes, Your Honor. Dr. Rogers, you are hoping that the plaintiff is successful here, correct?
Well, I certainly hope my testimony helps the jury make the right decision, yes.
And you want the door to be opened for some class action lawsuits involving Drufo, right?
I'm tired of seeing companies like Lush get away with things like this. I want to lend my expert testimony to that. I can't stand idly by.
So is that a yes? You want the door open for some class action lawsuits, correct?
Yeah, I can't stand idly by.
If there are more lawsuits, you hope you'll be hired more, right?
I want to lend my expert testimony to cases like this.
Is that a yes? You hope you'll be hired more, correct?
Yeah.
And that could mean a lot of money for you, right?
I'm not in this for the money. Money's not going to be worth anything after the world ends.
That I didn't ask whether you were in it for the money. I asked whether that would mean a lot of money for you.
Money that I'm not going to use, sure.
Now, let's talk about that study you designed. You had 3 groups, correct?
Yes.
One group had never been exposed to Drufo. That was your control group, right?
That's right.
And one group used products containing Drufo on occasion.
Yeah.
You never defined occasional exposure, did you?
Well, we obviously had it between never using Drufo and consistently using Drufo.
So could occasional exposure be once a month?
We kept it within reasonable bounds.
So to answer my question, could occasional be once a month?
Sure.
Could occasional be once a week?
Sure.
Could occasional be just in the summer?
Sure.
Now, you reviewed Ms. Weers' employee records, correct?
Yes, I did.
And Mr. Weers only had exposure to Drufo during the summer, correct?
Well, I know that he was a contractor or a landscaper for a number of years. So I would imagine that, from his employment records, I know that he used it pretty consistently.
She didn't use the chemical as much as farm laborers and gardeners, correct?
I think that he would. Again, I would put him in the heavy users if he were in my study.
Now you heard, so the third group of your study was exposed to Drufo on a regular basis, correct?
Yes, almost daily.
And this group included laborers who used the fertilizer in the field.
Yes.
And this group also included gardeners.
There were a few in there, yeah.
Farmers and gardeners don't have the same duties, do they?
I mean, they both work outside. They both make plants grow. I think that's pretty much the same.
But they don't have the same duties, do they?
I'd say that they basically do, yeah.
And Drufo wasn't the only chemical that these laborers were exposed to, was it?
Sure.
And these chemicals could have caused the cancer?
Regardless of any other chemicals present, my study found a 10 times
Dr. Rogers,
higher frequency of cancer.
I'm not asking about Drufo at the moment. I'm asking, could those other chemicals have caused the cancer?
It's unlikely considering the fact that Drufo causes 10 times more cancer.
But Dr. Rogers, that's exactly my point. You don't know whether Drufo actually caused 10 times the risk because of these other chemicals.
I feel very confident about the results of my study. I'm about as confident as I am that the world is going to end.
Now, all right, so now let's move on to your mitigation recommendations. So as part of your study, you made some recommendations about how to mitigate and prevent exposure to Drufo, correct?
Yeah.
You suggested to wear an N95 mask, right?
Yep.
And you suggested that they wear protective clothing.
That's right.
Dakota Weirs didn't take these precautions, did she?
Well, I think that the problem with that is that my warnings were on a tiny little label. They should have been plastered all over the bottle, huge font.
Dr. Rogers, Dakota Weirs didn't take those precautions, did she?
Unfortunately, he didn't.
Thank you. No further questions, Your Honor.
All right, thank you. Give our judges a moment and then we'll have redirect. Ms. Combe.
Yes, Your Honor. Dr. Rogers, you were asked about any financial incentives you may have in testifying today. Just to clarify for the jury, why are you here right now?
Well, like I said, I'm not doing this for the money. Money is not going to be worth anything when society collapses. I'm here to lend my expert testimony because I'm tired of seeing companies like Lush get away with things like this. And I think I need to advocate for people like Dakota Weirs.
There was also discussion of exactly what you meant by consistent users in your study. Could you clarify for the jury what that definition is?
Consistent users were people who use Drufo almost every day.
Why is Dakota Weirs a consistent user in your opinion?
Well, from what I saw in his employment records, he used Drufo almost every day.
And lastly, you were asked about recommendations you have for users of Drufo. What is your ultimate recommendation about Drufo?
Ultimately, don't use Drufo or not. Protection or not, it's a dangerous chemical.
Thank you, Dr. Rogers. Your Honor, I have no further questions.
All right, thank you, counsel. All right, I think we've given our judges a moment. Who's the next witness, please?
Your Honor, at this time, the plaintiff rests.
All right, thank you, counsel. Does the defense have any witnesses?
The defense calls Skylar Weirs.
All right, Ms. Dino, hang on just a moment. All right, Ms. Weirs, raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. Please introduce yourself to our scoring judges.
With my real name, Your Honor, or my character's name?
Your character.
My name is Skylar Weirs.
Thank you. Ms. Dino.
Good morning, Miss Weirs. Are you related to the plaintiff?
Yes, I am. Dakota's my twin brother.
And what is your current occupation?
Well, if you ever see me furiously typing in a coffee shop, you would know I was an investigative journalist. I also maintain a job at Applebee's. I'm always slinging around chicken and fries. And for what it's worth, I'm quite the carb buff.
Ms. Weirs, as an investigative journalist, what types of articles have you written?
Recently, I'm very proud my advisor chose me to write a series of articles on modern agri-tech. Coincidentally, I also wrote an article about Drufo before my brother was unfortunately diagnosed.
And what steps do you take to write these articles?
For my series, I've been researching for about, a year now. I use a lot of documents from the NSDA and, the National Association of State Departments of Agriculture. I compile all this information and then I put it together for my articles.
And after you compile all the information, have any of your articles been published?
Yes. Well, I published an article recently on questioning the link between Drufo and cancer.
And where are these articles published?
Through my magazine, The Rationalist. I'm not trying to do a promo here, but I think it's a pretty cool place to work.
What types of articles does The Rationalist publish?
We encourage our readers to ask the difficult questions about science. This means discouraging pseudo-scientific mass hysteria, which we often see in today's world.
Do you have any specific experience researching and writing about lush fertilizer and Drufo?
Oh, yes. For my series of articles, I researched the topic heavily.
Your Honor, we offer Skylar Weirs as an expert in agribusiness and agri-tech, specifically about the impacts of exposure to fertilizers, including Drufo, on humans and the environment.
Hang on just a moment. All right, so you're offering her as an expert on agribusiness, including agricultural technology, including the effects of Drufo. Go ahead.
Including the effects of Drufo on humans and the environment.
Ms. Cohn?
Yes, Your Honor. Permission to conduct a voir dire.
Of course.
Just a minute for me to set up my camera once. My apologies for the delay. Permission to proceed, Your Honor.
Please go ahead.
Good morning, Ms. Weirs. Howdy. I want to start off by talking about your formal education. You never went to college, right?
No. Once my career started taking off in journalism, I decided to forego.
Right, and because you decided to forego college, you have no formal education in toxicology.
No, I wouldn't say so, although I'm very well practiced on the subject. I write a bunch of articles about it.
So that's a yes?
Yeah, no college education.
You've never taken a formal class on chemistry?
Back in high school I did, but no, not in any institution.
Right, and you've never taken a class on something like environmental science, isn't that right?
No.
So everything you're going to tell us today is based off of your own independent research?
I don't like your connotation, miss. I do a lot of research from government agencies. These are very valid resources. I wouldn't say that my research is not able to be depended on. In fact, it's a little rude. I know I'm not some big old lawyer, but I have a lot of knowledge on the subject.
Ms. Weirs, with all due respect, I wasn't asking about the resources that you use to write your own papers, but everything that you're telling us today is based off of things you looked at yourself, right?
Yes, just like any investigative journalist.
Right. So just to clarify for the jury, you have no formal license in any profession as something like a toxicologist.
No, I'm no doctor or scientist, just a journalist.
You have no experience or training in things like the treatment of cancer.
Well, I have experience researching it a bit through my articles, but no, I'm not a medical doctor.
Your Honor, at this point in time, the plaintiff objects to the tendering of Skylar Weirs as an expert specifically in the effects of DRUFO on humans and the environment. Firstly, with the effects of DRUFO on humans, Ms. Weirs just testified that she has no formal training or experience or education whatsoever in the fields of toxicology, chemistry, or even environmental science, and isn't even a medical doctor. Furthermore, with the effects of DRUFO on the environment, that isn't relevant to today's case. We're asking whether DRUFO is carcinogenic or not, and whether it's good for the environment has no bearing on today's facts, and whether or not lush fertilizer is liable.
Dino?
Yes, Your Honor. So in regards to the relevance aspect of the effect of DRUFO on the environment, the plaintiff is claiming that the effect of DRUFO on humans is that it causes non-Hodgkin's lymphoma. That is the entire case today. Additionally, the aspect of DRUFO's effect on the environment is its nitrogen seeps into waterways. And not only does that affect the environment, but that can also cause non-Hodgkin's lymphoma, or so the plaintiff claims. Additionally, pursuant to Rule 702 and the court's pretrial ruling as of November 1st, a witness is qualified as an expert by knowledge, skill, experience, training, or education. Ms. Weirs displays the proper knowledge and experience due to her career centered around agritech and her in-depth knowledge on DRUFO through the articles and the in-depth research that she has done. Although Ms. Weirs does not maintain a degree in the related topics, she completes the required criteria. Additionally, under Rule 703, an expert opinion does not need to be based off of firsthand studies. It can be based off of secondhand research, which Ms. Weirs has plenty of.
If I may respond briefly, Your Honor.
You may.
Firstly, in regards to the response to my relevance objection, I'm sure as we all know, there's a huge difference between whether or not fertilizer can bind to a soil and protect the environment and the impacts it has biologically within the human body. Those are two extremely different things. The environmental impacts of DRUFO and the carcinogenic properties of DRUFO are extremely different, and we should not be talking about any environmental positive or negative impacts of DRUFO today whatsoever. Now, talking about the effects of DRUFO on the human body, as the plaintiff, we would not object to Ms. Weirs talking about dynamics within agribusiness and the different corporations within agribusiness, but providing any scientific knowledge or basis on the biological implications of DRUFO on the human body is something that Ms. Weirs simply does not have any experience, training, or knowledge to tender as an expert and testify about today.
All right. I will admit Ms. Weirs is an expert on agricultural business, including agricultural technology, as it includes the effect of DRUFO on humans and environment. And the reason for that is that with no college degree, no formal education in toxicology, no basis in chemistry, no environmental science classes, and not being a scientist, who could be a better expert? So I'm going to permit her to testify to that.
Ms. Weirs, you said you've reached some opinions in this case. What are those opinions?
Well, I would say I have two opinions today. First of all, although fertilizers are inherently dangerous, DRUFO is actually designed to be safer for users, and it's safer than other fertilizers, which would include more harmful chemicals. Furthermore, my second opinion today is that my brother should be blaming Haven Landscaping for his diagnosis, And if I'm being honest, he bears some weight of the blame for maybe jumping to conclusions about a product that's actually designed to be safer than other products have been in the
Speculation.
The aspect is speculative.
That Dakota Weirs was jumping to conclusions about the carcinogenic properties of Drupo.
Oh, I'm just going to overrule that objection. Go ahead.
So, Ms. Weirs, let's go back to your first opinion that Drufo is safer than comparative fertilizers. Can you describe some of the risks from modern agricultural products like fertilizers?
Of course. Well, fertilizers and agricultural products, they're all soaked in these chemicals, arsenic, glyphosate. The real problem, I would say, is nitrogen, and this can be real dangerous for people and also the environment.
And how does Drufo lessen the risk to the environment and to humans?
Well, I know I mentioned that I was into cars. I guess I would use getting in a car as a metaphor for how Drufo keeps people safe. Of course, when you're driving, there's always a risk when you're on the highway, but there are things you can do to make it safer for yourself. Just like that, there's always a risk when you're using fertilizers, but Drufo keeps people safer by keeping chemicals like arsenic and glyphosate, which are known carcinogens, out of their product. And because Drufo is actually an effective pesticide, it doesn't need to be applied as often, and it's safer for people to use, far less dangerous.
Can you briefly explain how Drufo works?
Of course. Well, Drufo is a product that just sort of binds the chemicals in a fertilizer together, and it's used in all Lush products.
And Ms. Weirs, are you aware of any study that has established a causal link between Drufo and cancer?
No, I guess not with any level of certainty at all.
And in your opinion, did the creation of Drufo help protect consumers?
Oh, yeah, definitely. It's much safer than products in the past, products of its competitors. It's designed to keep people safer.
Now let's move on to your second opinion, that Haven Landscaping has partial responsibility for Dakota Weir's cancer. What's the basis for that opinion?
Well, here's the thing. When my brother was working at Haven, he was using a whole host of products that could have included glyphosate, arsenic, excessive amounts of nitrogen. These products could have been far more dangerous than Drufo, but regardless of danger, Haven allowed my brother to work with these chemicals without proper protection as a teenager. And to me, that's just appalling.
Objection, Your Honor. Lack of personal knowledge. No foundation has been laid that Ms. Weirs has reviewed the employment records of Dakota Weirs and knows the kinds of chemicals he was working with.
Ms. Dino?
Yes, Your Honor. Skylar Weirs has been in trial today. We've previously heard testimony from Dakota Weirs on the lack of personal protective gear he wore, the fact that he worked at Haven, and the amount or the kinds of chemicals that he worked with at Haven.
This goes more to weight than admissibility. I'm going to let our jurors sift through it. So the objection's overruled.
Now, Ms. Weirs, I'll ask, do you believe that your brother also holds some responsibility for his diagnosis?
Well, I'm obviously very sad that my brother has cancer, but I do think it's strange that my brother and my family have jumped to the assumption that Drufo was what caused it. Through my research, I know that Drufo is a lot safer than other products that my brother would have been using. And I at least think he needs to take a step back and look at all the products that he would have been using and at Haven, who should be taking some of the blame.
And finally, Ms. Weirs, is it in your, why are you testifying today?
Well, I guess as a journalist, I'm a big supporter of the truth. I know that's hard to hear because some journalists are a bit corrupt these days, but really I'm here because I care about my research. I believe that I have a better perspective on what's going on just with my brother and with this company. And I'm here because I really believe that my brother needs to take a second look at the company he's accusing.
Is it in your financial best interest to testify?
No, I wouldn't say so. Actually, I guess if my brother wins the case, there'd be more money in my father's estate. And I would say that I would have more money when he dies, although money isn't really a big motivating factor for me here today.
Thank you, Ms. Weirs. No further questions.
Thank you.
Hang on just a moment. All right, we'll give our judges another second. Ms. Cohen?
Yes, Your Honor. Permission to proceed?
You may.
All right, Ms. Weirs, I want to start off by talking about your brother's employment at Havens Landscaping. Just to clarify, you didn't work with him there, right?
No, I did not.
And you never reviewed his employment records formally?
No, but of course I've heard what he's been saying about his employment today.
So that's a yes?
No, I never reviewed any sort of records for his employment.
You never met his coworkers or boss?
No, I didn't.
You have no connection to any of the management at Havens Landscaping, do you?
No, I do not. I was never affiliated with the company.
Now, just to clarify, you are Dakota Weir's biological twin, right?
Yes, that's correct. Although we're fraternal, I guess you would say.
Right. Now, you both grew up in the same home.
Yes, of course. We had a great childhood. I'm just sorry to see Dakota suffer so much.
Right. And you both went to the same high school.
Yep.
But the big difference was Dakota used Drufo around the same time you were in high school, right? When you were young.
Well, I know it's easy to assume that twins are the same people, or telepathy stuff, I guess you could say. But no, there are more differences than just Drufo to me and Dakota. He liked piano, I liked writing. There's a lot of differences between us.
Ms. Weirs, I'm afraid you got a little bit ahead of me. But when you were both living in the same home, going to the same school, your brother was using Drufo, right?
Yes, and other fertilizers for his job.
And you were not.
No, like I said, I didn't work at Haven. I wasn't a landscaper.
All right. Now, I also want to touch on something you surprisingly didn't mention on direct examination. A lot of your research centers around agritech, right?
Yes, that's correct. I write a lot of articles on the subject.
And you claim that older companies within the industry are targeting newer companies.
Yes, that can often be the case, especially in agribusiness. Oh.
Objection, Your Honor. Lack of foundation. This question, there's been no testimony to this, indirect, and opposing counsel has failed to lay any foundation about these older companies or any stance that has been taken on it.
Ms.
Can I
Cohen?
respond, Your Honor?
You may.
In order for me to question about something on cross-examination, it doesn't need to be brought up in direct examination. I'm asking Ms. Weirs about something that lies within her tendering today in court, something, a conspiracy theory she writes about within the Rationalist magazine. I have the rights to question her about it.
Ms. Dino, last word.
Yes, so the question was, you mentioned previously that older companies are targeting younger companies. That statement was not made. Ms. Weirs has made no statement about this. And just for the clarity to the jury, I want to make sure that it's not implied that she's already given a statement about this indirect examination, and that foundation is laid on what these older companies are, what younger companies are, and the relevance to this.
I can clarify my wording, Your Honor.
You may. Go ahead.
All right.
The objection's overruled, even so, and I'll let you go ahead and clarify.
So you believe that these newer agritech companies are being targeted by what you call the old guard, right?
Yes, the old guard of agritech business. This can happen a lot, and it could be happening with Lush as a company.
Right. So you're claiming today that Lush Fertilizer is being targeted by older agritech companies, right?
No, that is one thing that I talk about in my witness statement, but that's not my only claim here today. I'm not saying that this suit on Lush is because of an older company targeting this new revolutionary product. I guess I'm more here to talk about my brother's stance in it. It is an example I mentioned, though, just to provide some perspective on agribusiness.
Just to clarify, is it not your statement here in court today that you believe Lush is being targeted by older companies?
Yes, I do believe that in some aspect. And I could give you an example of that happening in the past. It could be something that's happening to Lush because of their new product that keeps people so much safer than the products of its competitors.
That's all right, Ms. Weirs. But just to make this clear for the jury, you can't name a single company that is actually targeting Lush today, can you?
Well, no, but I heard you call it previously a conspiracy. I'd just like you to know that I don't write about conspiracies. My whole job is to discourage conspiracies. This is a real concern, and it's something that's happened in the past to other companies. It could be something that's happening today, just based on scientific studies and research. People are trying to target the chemical as a product.
All right, Ms. Weirs, I'm afraid you got a little bit ahead of me. You're telling us that you want to tell us the truth today, but you can't name a single company that's targeting Lush?
No, I can't specifically, but it is a valid concern as it's happened in the past with other revolutionary products and developments.
You can't tell us a single person who is targeting Lush today, can you?
My brother could be targeting Lush as a company, Drufo as a product. I can't name any high up executives. I suppose Dr. Rogers' research goes against the company and their products as well.
So we're just going to have to take your word that Lush is being targeted?
Yes, I suppose you have to.
Right. All right. Thank you, Ms. Weirs. Your Honor, I have no further questions.
Your Honor, you're muted.
Sorry, my dog barked. Can you hear me now?
Yes.
Good. All right. Thank you for that. Go ahead, Ms. Dino.
I just have a brief redirect, Miss Weirs. Growing up, did you and your brother do everything together?
No, absolutely not. We had very different lives.
And you didn't work at Haven Landscaping, but what did your brother do separately than you?
I guess he played the piano. We have different interests. He worked at Haven using a bunch of different products. That's mainly the differences between us.
So in your expert opinion, could your brother have been exposed to non-Hodgkin's lymphoma in many different environments besides Haven?
Absolutely, and could have been exposed as well based on many different products, far more dangerous than Drufo and Lush fertilizer products.
Thank you, Ms. Weirs. No further questions.
All right. Thank you, counsel. Ms. Carboni, look, the rules are that there can't be a break unless there's an emergency. I need to go to the restroom, so we're going to take a moment, guys. I'm so sorry. All right. I'm ready when everybody else is, but if we need a minute or two because others needed a break, that's fine.
I'm ready, Your Honor.
All right, is our witness ready? Outstanding. All right,
Defense calls Blake Doncourt.
just a moment. All right, Ms. Doncourt, you solemnly swear or affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Introduce yourself to the members of our jury.
Good afternoon, members of the jury. My name is Blake Doncourt.
Thank you. Counsel,
Ms. Doncourt, what is your occupation?
I am the Chief Executive Officer of Lush Fertilizer. I'm also the founder. And ever since 2000, I've been working very hard to build the company from the ground up. And I've worked really hard to make a name for Lush, and I'm proud of what we've done.
What does Lush do as a company?
Well, Lush just wants to make fertilizer to sell to individuals, businesses, and government associations to give them green, luscious grass. I mean, green grass is part of the American dream, isn't it?
Do you donate to any environmental charities?
Yes. Lush donates 10% of its total profits to charities around the world that work to decrease the world's nitrogen footprint. Lush was awarded with the prestigious Business Sustainability Award in 2019, and I was personally nominated to win the Champions of the Earth Award back in 2020.
Do you understand Lush Fertilizer is being blamed for causing Dakota Weir's cancer?
Yes, obviously that's the reason I'm here today, and I just wanted to first say how terrible I feel for Dakota. It's a terrible illness. However, his accusations against my company are unfair and wrong. I resent being portrayed as this greedy monster because that's just not who I am.
There's been a lot of testimony today about Drufo. What is it?
Drufo, well, it's quite revolutionary, really. Essentially, Drufo is a bonding agent that we use in our fertilizers, but what's so great about it is that it has a reduced amount of nitrogen compared to other leading fertilizers, which helps Lush to work towards its goal of making the world a better place.
Before Drufo was put on the market, were there any studies conducted about its safety?
Oh, of course. Lush takes safety very seriously, and before Drufo was put on the market, we did extensive, detailed, and articulate research.
Did Lush's studies ever reveal an increased risk of cancer in humans from exposure to Drufo?
No, not at all. And to my knowledge, there's no valid scientific evidence with reasonable probability that Drufo is at all dangerous to humans.
Did the EPA, the Environmental Protection Agency, ever make findings that Drufo was at all harmful for public use?
No, Drufo is EPA approved, and there's no federal or state laws that require Lush to put any extensive warning label on our fertilizers. I mean, how can I put a warning label on my product when there's no science or data to support these baseless accusations?
Are you aware of the study performed by the plaintiff's expert, Casey Rogers?
Yes, I am.
Do you believe that study was reliable?
Well, not from what I've heard in court here today. I mean, it was never peer reviewed and it was never replicated, so it's hard to even call it a study at all.
Let's move on to a former employee of yours. Do you know Carson Durst?
Yes, I know Carson.
Did you give her a job at Lush?
I did, back in 2003, I believe.
And when did she stop working at Lush?
2006.
Did she quit or was she fired?
Carson was fired.
And why was she fired?
Well, at Lush, we hold our employees to a very high performance standard, and unfortunately, Carson's performance just fell far below that standard, so I had to let her go.
While working at Lush, did Ms. Durst sign a non-compete agreement?
Yes, she did.
And is this standard practice to have your employees sign these agreements?
Yes.
What is the purpose of Exhibit 5?
Well, Exhibit 5 is the non-compete agreement, and essentially it's just to ensure that our employees don't go off to any of Lush's competitors and incidentally disclose any of our trade secrets.
Now, can we please pull up Exhibit 5? What is the specific purpose of paragraph 1?
Well, paragraph 1 is the non-compete covenant. And again, that's just to make sure that our employees within at least 2 years don't go off and work for any of Lush's competitors. And well, Carson clearly violated this.
Does Terrace Greenery have a similar product to Drufo?
Yes, and coincidentally, it was developed just after Carson was fired from Lush and began working for Terrace.
And how long does this prohibition last in paragraph 1?
The non-compete covenant lasts for 2 years.
Now, can you please look at paragraph 2, the non-disclosure covenant? And you read it starting at the employee will not.
Objection, Your Honor. Relevance?
Your objection, Ms. Longi?
Relevance, Your Honor.
Ms. Carboni?
Relevance to the prohibition?
Mm-hmm. I think and maybe I'm wrong, I think the issue, at least from my perspective, is what the relevance of the non-compete is overall, as opposed to the non-disclosure agreement.
Your Honor, this shows the credibility of the witness, Ms. Durst, and that she's not credible in her statements.
Ms. Longi?
Your Honor, then I would, if they're using this to show the credibility of my witness, I would object to improper character evidence.
Is there a response to that?
Just that the credibility of the witness is always relevant, Your Honor.
All right. I'm going to let it in.
Thank you, Your Honor.
Let the jury decide. Objections overruled.
Now, can you please read paragraph 2, the non-disclosure covenant, and start at the employee will not?
Yes. The employee will not, at any time or in any manner, either directly or indirectly, divulge, disclose, reveal, or communicate any trade secret belonging to Lush to any third party, including but not limited to any competitor of Lush.
Now, does this have an expiration date?
No, the non-disclosure covenant lasts forever.
Now, let me ask you about Exhibit 4. That's the email Ms. Durst claims to have received from Jerry Lynn. Have you ever seen that email before today?
Well, no, I've only heard Carson reference it in testimony here today.
Did Lush provide all of its emails to the plaintiff that was on his email server?
Well, yes. The plaintiff's attorneys asked for Lush to hand over the entirety of our email server, which I gladly accepted.
Was Exhibit 4 on there?
No.
If Ms. Durst had any concerns whatsoever about Drufo, did she ever bring them to your attention?
No. And, that was one of the problems with Carson. It was her job to bring any concerns she had about any of my products to my attention, but she didn't. And I'm only just hearing of her concerns now.
Assume for a minute this email was genuine. Did Carson Durst have permission to make it public?
Well, looking at the email, no, because
Objection,
it
Your Honor.
had trade secrets.
Objection, hang on just a moment. There's an objection. Go ahead, Ms. Longi.
Your Honor, I would object again to relevance.
Ms. Carboni.
Your Honor, this shows that the witness was not credible and did not have the ability to share this email to the public.
Well, I think that the relevance is marginal at best, but I'm going to let it in and overrule the objection.
Does this email contain trade secrets?
Well, yes. As I look over the email, it clearly includes trade secrets about Drufo and the future
Objection,
testing
Your
of
Honor.
Drufo.
Lack
Go
of
ahead.
foundation.
That's overruled. Go ahead.
Thank you, Your Honor.
Go ahead, Ms. Davenport.
Well, as I was saying, if this email were authentic, as I'm reading over it, it includes trade secrets that Carson might have written. And that's part of the non-disclosure covenant. He is not allowed to disclose any of those.
Finally, Ms. Doncourt, do you believe you are responsible for Dakota Weir's emotional distress?
No. And again, I feel very sorry for Dakota. However, the recommendations that we put on our product, he wore no protective gear while working with any other chemicals as a landscaper. And furthermore, I'm concerned that there are many money-hungry
Objection,
lawyers.
Your Honor.
Go ahead.
Lack of foundation.
Response?
Your Honor, I will rephrase.
Thank you. The objection sustained. Go ahead.
Ms. Durst, do you believe you are responsible for what is happening today?
No, I don't. And one of my biggest concerns is that there are money-hungry lawyers trying to convince Dakota and sway her to.
Objection, Your Honor. Speculation.
Well, I'm more concerned that it's argumentative. Ms. Carboni?
Your Honor, this is not argumentative. It is solely the witness's perception of what is happening today.
I'll let the jury decide. The objection, though well-founded, is overruled. Excuse me.
Ms. Doncourt, do you believe you had anything to do with it today?
No. And again, I feel terrible for Dakota. However, my company is not responsible for her illness.
No further questions, Your Honor.
All right, thank you. We'll give our judges a moment. Excuse me. All right, Ms. Longi, cross-examination, please.
Yes, Your Honor. Good afternoon, Ms. Doncourt. I'd like to start off by talking about what Lush knew. As you stated on direct, you were aware of the Casey Rogers study, correct?
Well, I was aware of it today. The first time I've ever heard of it was in court.
Lush was also aware of another study for over 20 years, weren't they?
I'm not sure what you're referring to.
Absolutely, Ms. Doncourt. Let me clarify my question. You heard Ms. Durst testify in court earlier today,
Yes, I did.
and you heard her testify about a rat study.
Yes, I did.
You heard her say that she put that study into her company notebook.
Well, I mean, that's what she says, but I don't believe that.
And you heard her say that this study shows an ingredient in Drufo causing cancer in rats, correct?
Well, again, I don't believe that.
However, that is what Ms. Durst said.
Well, it's what she said, but that doesn't exactly mean that that's the truth.
Thank you, Ms. Doncourt. I'd now like to talk a little bit about Exhibit 4, the email. Could I please have my co-counsel screen share that? Now, Ms. Doncourt, this is an email, correct?
Well, it could be typed up on a Google Doc, who knows?
Now, if you could follow along in this document while I read aloud. In the second paragraph, it says, following our lab's June Drufo study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year. The document says that, doesn't it?
Well, I believe that this document is manufactured. I mean, if you look at it, my email address isn't even on there. I've never received this email before.
That was not quite my question, Ms. Doncourt. I'm simply asking what the document says. And the document states this sentence.
Well, I mean, this fake manufactured document does, yes.
Now let's go up a little bit on the email, and on the to line, on the second line of that, you see your name on this document, don't you?
Well, yes, I mean, it's pretty simple to spell someone's name, but again, I don't see my email address.
But your name is on the document, Ms. Doncourt.
Yes, that's my name.
Now, let's go up a little bit on the email, and on the to line, on the second line of that, you see your name on this document, don't you? Well, yes, I mean, it's pretty simple to spell someone's name, but again, I don't see my email address.
Yes, that's my name.
All right, thank you, co-counsel. You can go ahead and stop screen sharing. I'd like to talk a little bit about a process called baking, Ms. Doncourt. You're aware of what baking is, right?
Yes, I am.
Baking is a process where you apply a lot of heat to a product.
Yes.
Now, baking Drufo would have eliminated any possible risk, right, Ms. Doncourt?
Well, baking was irrelevant for Drufo, since Drufo, compared to other leading fertilizers, is much safer. So why would we bake a product where there's no science or data to support that claim?
Ms. Doncourt, I'm using your own words here. Baking Drufo would have eliminated any potential risk.
Well, again, with any fertilizer, there's going to be a risk, no matter how small. And compared to other fertilizers, Drufo limits that risk. So baking would be irrelevant.
Well, since baking was when you decided that baking was irrelevant, as you said, Ms. Doncourt, you conducted a financial analysis, correct?
Yes, I did.
You calculated how much it would cost to bake Drufo.
Yes.
And you would recognize a copy of this analysis, wouldn't you?
Yes, I would.
Could I please have my co-counsel screen share what has previously been marked as Exhibit 8? Now, Ms. Doncourt, this is your financial analysis.
Yes, it is.
And it is a fair and accurate copy.
Yes.
Your Honor, at this time, the plaintiff moves to enter Exhibit 8 into evidence.
Is there an objection?
Yes, hearsay and best evidence.
All right, let's start with the hearsay argument.
Yes, Your Honor. This is a statement of party opponent, as it is a document created by Blake Doncourt herself. Therefore, it is not hearsay.
All right. Ms. Carboni, what about that?
This is an out-of-court statement being used for the truth of the matter asserted. As she stated, Ms. Doncourt testified that she created it and is therefore made by a declarant.
But what about the notion that it is the opposing party's statement 801D2?
Under 801D2, this statement is used to show that the truths of the assertions in the contract are correct. And
oh, I'm sorry, go ahead.
And it's hearsay under the opposing party statement.
All right. Certainly the best evidence rule objection is overruled, and I'm going to admit it otherwise under notwithstanding the hearsay objection.
Thank you, Your Honor. Now, Ms. Doncourt, let's take a closer look at this document. Under baking costs in the year 2004, the number states $250,000, doesn't it?
Yes, it does.
And then in 2005, the baking cost would have been $252,500, correct?
Yes, that is correct.
Now, over the course of 10 years, this cost would have added up to $2.6 million, correct?
Yes.
Thank you. You can go ahead and stop screen sharing now, co-counsel. Finally, Ms. Doncourt, when you made the decision not to bake Drufo, you stated that it was just too much money for the little risk, didn't you?
Well, again, yes. Drufo, with the limited amount of risk it has, it would be irrelevant to spend $2.6 million baking a product that's already safe. And ma'am, I'd just like to say that if there was any significant or valid risk that Drufo was at all dangerous to
Objection,
humans.
Your Honor. Non-responsive.
I'm going to sustain that objection. Go ahead and ask
Thank
another
you.
question.
Now, Ms. Doncourt, I'm using your own words here. Baking was just too expensive for the little risk? Yes or no?
Well, as I said, it was just irrelevant because as with other leading fertilizers, it wasn't
Objection, Your
worth
Honor.
that much money.
Non-responsive. I've asked the witness a very clear yes or no answer, and she is not giving me that answer.
The objection sustained. I will let Ms. Carboni clean this up on cross-examination. So it is a yes/no question. I'm going to expect a yes or no answer.
So, Ms. Doncourt, that's a yes to my question.
Well, I suppose.
Thank you, Your Honor. No further questions.
Redirect, please.
Ms. Doncourt, why didn't Lush bake Drufo?
Well, Lush didn't bake Drufo because Drufo was just a lot safer than other leading fertilizers. Spending $2.6 million is just irrelevant for an already safe product. And I would just like to say that if there was any scientific or valid significant evidence that Drufo was at all dangerous, I would have never allowed my company to put that product on the market.
Would you have spent this $2.6 million if you felt it was necessary?
Absolutely. Again, if there was any significant risk that Drufo was dangerous, I would have immediately baked the Drufo.
No further questions, Your Honor.
All right, thank you, Ms. Carboni. This witness is excused. Thank you, Ms. Doncourt. Give our judges a moment. All right.
The defense calls Dr. Devin Williams.
I'm going to slow play this for a second and give our judges another brief moment. Hang on, Ms. Markle. All right. I'm sorry, who's your next witness?
Dr. Devin Williams, Your Honor.
Okay. Dr. Williams, please raise your right hand. You solemnly swear or affirm under penalty of perjury that the testimony you're about to offer will be the truth, the whole truth, and nothing but the truth.
Absolutely, Your Honor.
Thank you. All right, introduce yourself to the jury, please.
Yes. Good afternoon, members of the jury. My name is Dr. Devin Williams, Williams.
Thank you. Mr. Markle.
Good afternoon, Dr. Williams. What is your occupation?
Well, I am the lead toxicologist for Lush Fertilizer.
And were you asked by the defendants to give some expert opinions in this case?
Yes, I was.
Did you reach those opinions?
Absolutely.
Before we get to those opinions, let's talk about your background. Can you tell the jury about your education?
Well, I've received my BS, MS, and PhD all at the Colorado State University in Fort Collins. I also have a specialized post-PhD in pharmacy toxicology at the University of Utah.
Do you hold any certifications or accreditations?
I do. I hold many accreditations. Let's see. I have an accreditation in Colorado, Utah, New Mexico, and who could forget Wyoming?
Are you on the faculty of any academic institution?
I am. I work as an assistant professor at the University of New Mexico School of Pharmacy.
And what courses do you teach there?
Well, I teach three fantastic courses. That's forensic toxicology, principles of forensic toxicology, and my personal favorite, toxicology of environmental and occupational chemicals. That one's super interesting.
Before you worked for Lush, did you have any other employment in toxicology?
I did. For a brief stint, I worked under the chief and medical examiner at the Larimer County office.
And how long have you worked for Lush?
Well, just about for over a decade, but I've been the lead toxicologist for 7 years.
What are your duties as the lead toxicologist?
Well, as the lead toxicologist, I oversee all of the environmental effects of the products produced by Lush Fertilizer. This could be, for example, alcohol in neurochemical pathways or inorganic compounds found in agricultural enhancing organophosphorus products.
As part of your expertise and training, do you have to reach conclusions about the effects of potentially toxic chemicals?
Yes, I am trained to understand how all of these chemicals affect the human body
Do you also have to reach conclusions on the environment?
on a daily basis.
Your Honor, the defense now offers Dr. Devin Williams as an expert in toxicology and the effect of DRUFO on humans and the environment.
All right, any objection or voir dire?
No objection, Your Honor.
All right, so Dr. Williams is an expert on toxicology and the effect of DRUFO on humans and the environment.
All right, Dr. Williams, you said you reached some opinions. What are they?
Yes, my opinion is that simply DRUFO does not cause non-Hodgkin lymphoma.
What did you do or rely on to reach those opinions?
Well, at Lush Fertilizer, we conducted many different research experiments using biomolecular and biochemical markers. However, we mainly relied on the fundamental process of statistical analysis and scientific math.
Did you have any involvement with the development of DRUFO?
Well, yes, I was hired as a research technician at Lush Fertilizer during the first 2 years of the development of DRUFO.
Do you know why DRUFO was created?
Yes, DRUFO was created to essentially address the influential and substantially negative effects that every fertilizer has on the environment, but more specifically to combat the negative effects of nitrogen.
Can you explain to the jury those issues with nitrogen and fertilizers?
Absolutely. So every fertilizer that exists has nitrogen, and when fertilizer is sprayed onto plants, excess nitrogen is ultimately consumed by bacteria, which produces an ecologically devastating byproduct, nitrates. Now, these nitrates lead to a form of agricultural erosion, which is eutrophication, which not only decreases the oxygen content in water, but can produce algae blooms, which produce very harmful bacteria to humans.
And where does DRUFO fit into all of this?
Well, DRUFO is essentially a bonding agent. It acts as a glue. Not only does it glue the actual chemicals within the fertilizer to each other, but it glues the fertilizer to the plant itself, which results in an overall decreased releasage of nitrogen into the environment. I could go into a more complicated analysis of that, but I'd have to use terms like coagulated hydroxylaptite and phosphate precipitate.
And now, is there still nitrogen in DRUFO?
Yes, there is still nitrogen in DRUFO. Every fertilizer contains nitrogen. However, because of DRUFO's bonding nature, less overall nitrogen is ultimately released into the environment.
And has the U.S. Department of Agriculture approved the use of DRUFO?
Yes.
And now you said you reached some opinions on that DRUFO likely did not cause Dakota Weir's non-Hodgkin's lymphoma. What is the basis for that opinion?
Well, yes, the basis for that opinion, to put it very bluntly, is that there is not a statistically significant increase in the contraction rate of non-Hodgkin lymphoma when you compare that to other DRUFO fertilizers.
Now, what did you find through your study?
Well, as I already said, we basically compared two different test groups. The only variable that we changed was the presence of DRUFO. Both test groups had very similar environments. And when we ultimately pulled the numbers from our test, we found that both different fertilizers had very similar incident rates of the contraction of non-Hodgkin lymphoma.
And why are you comparing users of DRUFO to users of other fertilizers and not just to non-users?
Because to draw accurate conclusions, you ultimately have to compare apples to apples.
Did you review a study performed by Dr. Casey Rogers?
Well, I hazard to even call it a study. I'd compare it more to a middle school science fair project.
Do you have an opinion on the validity of that study?
Yes, it is unequivocally invalid.
What is wrong with Dr. Rogers' procedures?
Well, first of all, the specificity of variable usage that is present within my own study is completely missing. Dr. Rogers flipped the nature of scientific research on its head. Let me remind you that non-Hodgkin lymphoma is a cancer that is contracted by environmental exposure. So in order to perform an accurate study on DRUFO, the only variable that you can change is DRUFO. However, Dr. Rogers used DRUFO as a dependent variable. The only thing that his study really shows us is the difference in contraction rate between common gardeners, farm laborers, and individuals who do neither of those things. With so many constraining variables, you cannot accurately determine anything from his study, and that's only one reason.
What are the other reasons?
Well, more reasons are that it hasn't been peer reviewed, it hasn't been publicly replicated, and it's never been published in a scientific journal. Furthermore, I just heard Dr. Rogers testify to all sorts of conspiracy theories regarding doomsday scenarios and that she's a bunker contractor. As someone with over 10 years of experience in the field of pharmacotoxicology, it's very easy to see all of the flaws in Dr. Rogers' study.
Now, do your findings agree with Dr. Rogers' study?
No, not at all.
And in conclusion, do you believe that there is any valid evidence that Drufo causes non-Hodgkin's lymphoma?
There is no valid evidence to even consider that Drufo causes non-Hodgkin lymphoma.
Thank you, Dr. Williams. No further questions, Your Honor.
Thank you, counsel. Give our judges a moment. Hang on just a sec. All right. Ms. Ryan,
Yes, Your Honor.
whenever you're
Dr.
ready
Williams.
for cross.
Dr. Williams, it would be bad for you if Drufo caused cancer, wouldn't it?
Well, yes, that could cause a whole host of bureaucratic roadblocks, which would ultimately ban or just prohibit Drufo from being entered into the European Union and other countries. So yes, that is correct.
Well, and additionally, Dr. Williams, you've been working as the head of the research labs at Lush for 7 years, correct?
Yes, that is correct.
Drufo is a very important product for Lush fertilizer, isn't it?
Absolutely, it is revolutionary to the entire market of fertilizers.
And Dr. Williams, Lush fertilizer pays your salary, don't they?
Yes, Lush Fertilizer does pay my salary. However, I'm also a professor at the University of New Mexico.
Well, Dr. Williams, it is your belief that you yourself have a financial bias in the outcome of this case. Isn't that
I do
true?
admit that. However, you also have a financial bias as a lawyer. Dr. Rogers also has a financial bias as he's trying to carve out a niche as an expert witness. Everyone in this case has a financial bias. Even Dakota Weirs, who is suing Lush
Dr.
Fertilizer,
Williams,
has a financial bias.
I'm not asking about anyone else, just you. And you have
yes,
a financial bias.
I would admit that I do have a slight financial bias as I am employed by Lush Fertilizer.
Let's talk about some forms of fertilizer your company's created. Drufo is banned in the European Union, correct?
Yes, according to the European Nitrate Directive, Drufo is sadly banned in the European Union.
And because of that, Lush Fertilizer sells a product that contains no Drufo there.
Yes, but I would like to make it abundantly clear that Drufo was not banned because of concerns over it, whether or not it causes non-Hodgkin lymphoma.
Dr. Williams, you've gotten a little ahead of me. My point is that your company sells a different product in Europe than in the United States.
Well, the only difference in that product is that it does not contain Drufo.
Exactly. Your product that you sell in the United States does contain Drufo, doesn't it?
Well, yes, that is because it is banned in the European Union, ma'am.
And so you're telling me that Lush Fertilizer sells a different product in the United States than in the European Union, yes?
That is correct.
Now let's talk a little bit about you. You're a published scientist, aren't you?
Yes, I've published numerous research articles.
One of those research articles was on ethanol exposure in mice, wasn't it?
Yes, that is correct.
Another one was on female hormones in mice.
Yes, that is correct.
You've published a study on false negative drug testing, haven't you?
Yes, I've published all sorts of different studies. My work as a scientist expands into many different areas of the world of science, ma'am.
Dr. Williams, you've never published a study specifically on cancer, have you?
No, I have not, but all of my training and education has given me the skills and tools that I need to do research and to do studies on cancer.
Dr. Williams, that wasn't my question. I'm just asking that you haven't published specifically on cancer, and that's true.
Yes, that is correct. I have not published articles specifically on the causal effect of cancer.
You also haven't published articles specifically about non-Hodgkin lymphoma.
Well, non-Hodgkin lymphoma, ma'am, being a cancer, that would also be a no.
let's talk about something else that you decided not to publish. It's your belief today that Drufo doesn't cause non-Hodgkin lymphoma, isn't it?
Well, you can't. Yes, that is my belief.
Dr. Williams, you say you've done studies to prove that.
Yes, that is correct.
You say you've done statistical analyses.
Yes, that is correct.
Dr. Williams, you've never published any of those studies to the public, have you?
Well, I didn't include any information on that within my witness statement. Would you still like me to answer that question?
Exactly, Dr. Williams. You didn't put it in your witness statement because you haven't published it, have you?
Well, I never said I didn't publish anything in my witness statement. But in my witness statement, no, I did not say that I published any articles.
On direct, you said it was a problem that Dr. Rogers' study has never been publicly replicated, yes?
Yes, that is correct.
Dr. Williams, your study has never been replicated by the scientific community outside of Lush Fertilizer. Isn't that true?
Oh, again, I never touched on that within my witness statement. I would love to answer that question if you would allow me to.
Dr. Williams, the reason it's not there is because you didn't do it. Isn't that true?
Well, ma'am, I felt there was no need to include any information on that. My standing and ultimate, all of my research and my background as a scientist, I felt that the information that I provided was sufficient enough to give a very clear outline of what I believed in this case. I felt that including that information was really not necessary.
So, Dr. Williams, the jury hasn't seen those studies, though?
No, the jury has not.
And because of that, Dr. Williams, we're just going to have to take your word for it. Yes?
Well, yes, you should take my word for it. And I believe I laid out all of my accreditation.
Stop.
Thank you, Your Honor. I have no further questions.
Thank you. All right, redirect. Let me get
Redirect, Your Honor.
Let me give the judges just another moment. Okay. Go ahead, counsel.
No redirect, Your Honor.
Good. Hang on just a sec. All right. Does the defense have another witness?
The defense rests, Your Honor.
All right, thank you. Let's give our judges a second and then we will have closings. So I don't think this is gonna work. It's almost too late anyway. We're almost done. But
I have other headphones.
All right, is everybody ready for closings?
Yes, Your Honor.
Yes, Your Honor.
All right, is there? Are judges ready for closings? Good. Ms. Ryan, is this you?
Yes, Your Honor, it is.
Outstanding. Whenever you're ready.
They knew the risk. They sold it. And today you've seen all Hush Fertilizer had to do was put in a little bit of time and a little bit of money to make a safe product. But you've seen they didn't do that. So even though Lush Fertilizer knew the risk, they sold it. And today, the plaintiff is suing Lush Fertilizer for negligence. And that meant it was our job to prove to you today Three things. One, that Lush Fertilizer knew or should have known that their product was unreasonably dangerous. Two, that they could have eliminated that danger and simply chose not to. And that these choices caused Dakota Weirs to develop non-Hodgkin lymphoma. And we had to show you those things with the preponderance of the evidence, meaning more likely than not, which is exactly what we've done by showing you that Lush Fertilizer knew the risk and they sold it. And let's go through those things. One, Drufo causes cancer. You heard today from Dr. Rogers about her study. Her study which showed you that people who use Drufo every single day, people exactly like Dakota Weirs, were 10 times, 1,000% more likely to get cancer. Two, they knew the risk. Members of the jury, the defense time and time again tried to keep out the testimony of Carson Durst because the defense knows that Carson Durst can prove that they knew the risk and ignored it. You've seen today from Carson Durst about the email, about the studies, about the meeting in which a Lush Fertilizer employee stood up and said, not only was Drufo dangerous, but it could cause cancer. They knew the risk. Three, they could have eliminated the danger. Today, you heard a lot about a chemical process called baking, which would have eliminated any possible risk that product ever could have done. But Blake Doncourt took the stand and you saw exactly why. Lush Fertilizer chose not to bake their product. Blake Doncourt himself told you it was just too much money. So even though Blake Doncourt knew the risk, even though she knew how to stop it, she sold it. And when she sold it anyway, she hurt people like Dakota Weirs, who after using Lush Fertilizer got non-Hodgkin lymphoma, who now can't play the piano, can't go to Juilliard, can't walk around his own home or hold a job or do anything that he had dreamed about. And for that, members of the jury, we're asking for damages. We're asking you for $500,000 for the money, for the pain and suffering Dakota Weirs has already experienced, and $5 million more for the pain he'll experience in the future. Because today, it wasn't that Dakota Weirs was trying to find the person with the most money in their wallet, it's that he was trying to find the person who gave him cancer. And members of the jury, that person was Lush Fertilizer. Find them liable. Thank you.
Thank you. Ms. Dino, is this you?
Yes, Your Honor.
Whenever you're ready. Oh, no, let's give one more brief second
No worries.
for our judges. All right. Whenever you're ready.
Ladies and gentlemen, thank you for your time and attention. The plaintiff just tried to convince you that this case is about knowing the risks and selling it anyway, but it's not. This is a case of a young man's cynical search for a deep pocket defendant. It is undisputed in this case that Dakota Weirs has non-Hodgkin's lymphoma and that he is suffering. But emotion is not evidence. While working in Haven Landscaping, Mr. Weirs ignored the safety precautions listed on Lush Fertilizer. He disregarded the Lush label that told him to wear a mask and cover exposed skin. This directly relates to jury instruction number 8, which explains that the plaintiff is at fault if he failed to do something that reasonably careful people would do under the same or similar circumstances. So the question becomes, would a reasonably careful person wear a face mask and a long sleeve shirt when working around harsh chemicals for hours on end every day? Yes, a reasonably careful person would. In order for Lush Fertilizer to be negligent, the plaintiff must prove that Mr.
This
Weir's
isn't working for some reason.
sorry, Your Honor, is there a discrepancy? Okay.
Oh, go ahead. I'm sorry.
No worries. That Lush Fertilizer must have known that Dakota Weirs was one of the people they could have reasonably expected to use the product. Lush Fertilizer expected trained landscapers and agricultural workers to use their products with a sufficient personal protective equipment, not a 14-year-old boy without safety gear. I want to remind you of jury instruction number 3, which states that plaintiff must prove that Lush Fertilizer knew that Drufo was potentially harmful and did not take reasonable care to warn the user. Dr. Devin Williams, head of Lush Research and Development Labs, testified that he led thorough investigations into Drufo and did not find an elevated risk of causing non-Hodgkin's lymphoma. Because Lush found no potential risk to users, there was no need to label their product with a warning, as there was nothing to warn the user of. Carson Durst claims that she took part in a study that proved a causal link between Drufo and cancer. However, the only proof of the study existing is in Ms. Durst's testimony. There's absolutely no record of this study ever existing. Blake Duncourt, the CEO of Lush, allowed the plaintiff to search through her email, where they hoped to find evidence of a causal link, and they found nothing. Without a paper trail, the plaintiff cannot prevail. The only evidence of Drufo having a causal link is found in one study done by Casey Rogers. This study has never been published in a scientific journal, didn't follow reliable scientific protocols, didn't compare users of Drufo to users of other fertilizers, and was never peer-reviewed or replicated. She claims that her study is relevant because Dakota Weirs used Drufo almost every day. But Mr. Weirs only was employed during the summer. Dr. Rogers hopes to build a career on testifying as an expert witness based on her study. In her own words, Dr. Rogers is as confident in her study as she is that the world is going to end, and has the same amount of actual science to back up both claims. Let's take a look back to jury instruction number 10, which says that any finding you make must be based off of probabilities, not possibilities. The plaintiff can only tell you it's a possibility that Lush Fertilizer caused Dakota Weirs' cancer, because they don't know the other fertilizers he was exposed to while working at Haven. Even Dr. Rogers testified that other chemicals could have caused Mr. Weirs' cancer. In Dakota Weirs' own words, he is suspecting that Drufo caused his cancer. Haven Landscaping should be held accountable for its negligence and improper work conditions. A host of harsh fertilizers and chemicals were placed in the hands of Dakota Weirs when he was 14 years old. Lush Fertilizers has been studied. We know it's not dangerous than the many other products Haven allowed her to use without protective equipment. But why sue a small landscaping company when you could sue one of the most successful fertilizer companies in the nation? Haven should be grateful that their pockets weren't deep enough for Dakota Weirs, or they may be on the other side of this trial. When Dakota Weirs was asked on cross-examination, Mr. Weirs confirmed that he was suing Lush for their deep pockets. Ladies and gentlemen, Haven Landscaping may have failed their responsibility to protect Dakota Weirs, but it's not too late to fulfill your responsibility. Find for the defendant. Thank you.
Thank you. Give our judges another moment.
Of course, Your Honor.
Ms. Ryan.
Can you all see and hear me clearly?
Whenever you're ready.
Yes, Your Honor. Members of the jury, the entire case theory the defense has brought before you today is simply illogical. It's illogical because why would Dakota Weirs go after a company with maybe a few $1 million if that was what he needed? Members of the jury, the logical thing here is that Dakota Weirs went after the company that caused him non-Hodgkin lymphoma. Today, Blake Doncourt told you, and I wrote it down so I would not forget it, that she didn't want to be known as greedy, and yet she chose not to spend money knowing her product was dangerous. She knew the risk. and she chose not to make it safer. Members of the jury, that's what this comes down to. They knew the risk. They ignored the risk, and they sold it and find them liable. Thank you.
Thank you, counsel. Case is submitted. Well done. Let's give our judges a few more minutes to clear the decks here. And then what I'd like to do is we have four esteemed and experienced lawyers. And on the one hand, I want to respect all your time. We did go a little bit late, and that's on me. But I want to talk to the captains briefly while the judges are finishing up. Would you rather just to have time to prepare for the next round, or do you want to hear comments from these experienced attorneys?
Team Jim would love comments.
Your Honor, Team Ryan would love some comments as well.
All right, good. All right, so we'll give it a minute for our judges to finish scoring and then make sure you submit. And I suspect what we're going to probably do, although there's lots to say about the witnesses because we had an exceptional group of witnesses this time, is that we'll probably focus more on the lawyers, but to the extent that the judges want to comment, of course, on the witnesses, they're free to talk about whatever they like. And then if there's time at the end, I will. So,
Your Honor, I've submitted my ballot, so I am ready.
All
to
right,
proceed.
Lieutenant Monk, please. Tell us a little bit about yourself first.
So I don't influence any scores. I'll just quickly introduce myself. I am Lieutenant Nicholas Monk. I am a JAG officer in the United States Navy. That means that I am a lawyer in the United States Navy. I'm a graduate of the University of Colorado Law School, though I am currently speaking to you from Pearl Harbor, Hawaii, where I am based. It was a very early morning for me.
Wow.
But, I love doing this, competed in mock trial all through law school and various other kinds of debate and competitive public speaking in middle school, high school, undergrad. I am currently a criminal defense attorney, so really enjoy seeing how talented everyone was today. Would happily try a case with any of the attorneys that were present today. So well done. And that's who I am.
Good. Any comments you want to share, please?
My preference would be to hold off until all of the ballots are submitted, just to avoid any even appearance.
Thank you for that.
Influencing other judges. Though, yes, I would love to share some comments.
Good.
Mine is submitted, so.
All right, Mr. Scarpato.
I have all those score sheets submitted.
Yeah, mine is submitted as well. Thank you.
All right. Go ahead, Lieutenant.
Certainly. Well done, as I already flagged. Very, very impressed with all of the attorneys' performance. Also, I think very, significant props for very high level of professionalism, very high level of appropriate competitiveness. So really, really well done to the attorneys as well as the witnesses. I think that this was a really, really good round. I think everybody displayed a exceptional knowledge of the record. You clearly have worked this problem very, very thoroughly, and extremely impressed with the attorneys as well as the witnesses' knowledge of the record. If I have two areas of improvement, I obviously know that this is the state championship tournament, so not saying you have to throw everything out, but if you're going forward in later, if you're competing again next year, if you are planning on competing on a collegiate or law school level, I think opening statements across the board were highly argumentative. So one area that everyone could sort of work on is walking back some of the argumentation that I saw present in opening statements, and two, the hearsay rule of evidence. Now, it's extraordinarily complicated. You're high schoolers, so I think I'm really impressed with where you are at with the rules of evidence and even with hearsay, to be honest with you. But I think either team could have gotten at least a few more points by either more frequently correctly identifying and objecting to hearsay, and then from the flip side, doing a more thorough job of arguing hearsay exceptions or why a statement was non-hearsay. I want to be clear, you're really doing extraordinarily well for high schoolers arguing the rules of evidence and hearsay, but I think everyone had the opportunity to get at least a few more points from me, specifically related to the rule that forbids hearsay evidence and hearsay testimony being offered. But really, well done. Would say that I've seen current practicing attorneys that you are already at the level as high schoolers. So extraordinarily impressed with everybody, and standing by if you have any follow-up questions for me about my comments from this round or what it's like to be a lawyer and an officer in the United States Navy.
All I can say is that it is one of the most sought after and prestigious and helpful and professionally enriching jobs that somebody can have.
Thank you, Your Honor.
So well done, and thank you for your service. As a judge, I talk to people when they when they enter guilty pleas, I ask them if they're in the service because we offer services to them. And I never know what to say to adequately thank people for their sacrifice. So thank you. Ms. Capel. Is it
Hello.
Capel? Am I right?
Yes, you are. That's awesome. Most people mispronounce it. I am not a lawyer. I have no desire to be, nor could I do what all of you have just done. I prefer to be in a support position and work in the background when it comes to law, but my career took a non-traditional path. I received I started working as a legal assistant paralegal over 20 years ago, got an associate's degree in paralegal. And then I started working in the corporate world doing contract administration, and got my bachelor's in management and then later my master's in organizational leadership. And what I do, like I said, it was non-traditional for a legal person. Was I ended up, I am now the director of corporate contracts. I'm the corporate secretary, and I am the ISO 9001-2015 quality management system management liaison at a geospatial company in Colorado Springs. And I've been there almost 16 years now. So I also interface with our outside counsel. We have a firm in Denver that we work with if and when we do need outside counsel for that. But I'm pretty much on the front lines for coordinating all of our legal type things and contracts and subcontracts. So kind of interesting job. And my hat's off to you guys if you do end up going to law school and being a lawyer. A lot of it has to do with performance. And some of you were quite good at that, especially witnesses. But to kick over to the attorneys today, I think on the plaintiff side, Olivia, your passion really showed through when you were giving some of your arguments and working through that. I liked that you did tie to the main points. It was apparent that you had the material well at hand, that it was memorized, it was very fluid, it was very natural. On the defense side, Leah, excellent work. I think the defense team was very smart to put Leah in a position to be able to have a performance several times, and also to give the closing arguments as well. I think Andrew on the defense side as well, I think you were very smart when you were interviewing your witness, Dirksen, I believe. And you just kind of had short pointed questions and let the witness do all the work for you. And a lot of times, again, it's about performance. And when you're sitting in the jury, the last thing you want to be is bored. And the more you can get, get kind of into it as a story and let that work for you with the, having the law behind you, that's excellent. I think to kind of echo what the lieutenant said, if I had any criticisms, it would be, I think there were probably some missed objections that were out there and available for you. And then there were a couple items where there were some, you know, when you're sitting in the jury, there was a couple objections where it was kind of like, okay, you're kind of, you know, let's move on from here, where it may have been smarter to choose some other areas to jump in on. But I think that's all the comments that I have. Thank you.
Thank you very much. Excellent. Ms. Woodcock.
Thank you, Judge. Well, I guess first introduce myself. My name is Kellen Whitcup. I went to CSU for undergrad and then Harvard for law school. And I work at a couple of Denver law firms as a civil litigator for a few years. And then a couple of years ago, I took a job at the University of Colorado as a lawyer for the university, which is a really interesting and I think great way to practice law. And so like some of my co-scoring panelists, I'm happy to chat about that at any point if anybody's interested. For the feedback, I don't want to sound like too much of a broken record, but I thought you all did a really phenomenal job. Just the confidence and the mastery with which you put on your cases, from witnesses to the attorneys, was really impressive, particularly in a case file like this that has some technical and complicated aspects. I really thought that showed through, which was really successful. I also, and particularly at one point, everybody's knowledge of the rules, both of evidence and of the proceedings, was, I think, really, really impressive. I also saw a lot of instances of attorneys in particular responding kind of in the moment to either arguments made on objections, or if a witness was not quite getting where you needed them to be, or on cross gave you a little nugget, which is one of the hardest things I think about trial practice is, you know, being in the moment and thinking on your feet and having to kind of switch and adapt. And I saw some really great instances of that across both teams. If I had just a couple, you know, things for you all to consider as you move forward. You know, there were some new takes, I would say, on the case file across both teams that I haven't seen in previous rounds, which some were successful and others, I would say, you know, if you're going down a line of questioning and you're really wanting to get a point across, particularly if some objections get made or some, you know, kind of roadblocks get put up in your line of questioning, really just circle back before you move on to say, did I hit home the point that I wanted to make in that line of questioning? If you're not sure, just see if you can kind of get a nice conclusory, you know, question and answer there, because there were a couple of lines of questioning that I was having a hard time saying, okay, where are we going? What's kind of the punchline here? I didn't think, I thought in some instances, a little bit of a finer point could be made to help the jury understand what you're trying to say. But overall, really, really good job.
Thank you. And Bill Scarpato.
Thank you, Judge. And thank you to all of the contestants for the excellent presentation. That was really enjoyable to watch. First, a short introduction of me. My name is Bill Scarpato. I am an assistant United States attorney here in Denver, Colorado. I'm not a federal prosecutor. I work in the civil division. So essentially, anytime that the federal government sues or gets sued, I'm the person who stands up in court, at least here in Colorado. I went to Temple Law School in Philadelphia, where I'm from, for law school. I clerked for a federal judge for a couple of years after that, and then spent a couple of years in private practice at a couple of law firms before joining the United States Attorney's Office a couple of years ago. So
when did you join 2 years ago?
It was May of 2020
Nice.
that I joined. Yeah, just after the pandemic started. So I still haven't met several of my colleagues in person, which is weird. But I echo the offer of the other panelists. If anybody has any interest about eventually becoming a lawyer for the federal government, I think that it is the best job in the entire world, except for perhaps for Judge Schwartz's. So I love it, and I'm happy to speak with anybody who has any interest about that. I do not have personally really any mock trial experience, so please take my comments as a person with experience of the courtroom and not as a person with lots of experience in the mock trial context specifically. First global comment, I was super impressed. I agree. If any of you choose to go into the legal profession, you will be right at home. Really excellent. I was really impressed. And then a few global comments, and then I just wanted to shout out a couple of people with some honorable mentions who really stood out to me. I thought actually, I echo Lieutenant Monk's comment about looking again at the hearsay rules, which are ridiculous and Byzantine. But if you want an area of improvement on objections, that would be one to look at. That said, I actually thought that the objections on both sides were very judiciously used. Speaking as a juror in this context, we just want to know what happened. And the moment that objections go from making sure that the evidence that we're hearing is reliable and into kind of gamesmanship is when the line gets crossed. And I didn't see that here. And I really appreciated that as a juror and as a trial practitioner. I was impressed by how well you all chose your shots. I thought the witnesses uniformly handled cross-examination extremely well. You all seem to give up the admissions that you had to maintain your credibility, but were able to come back to your key themes, which is something that we work with witnesses in witness prep all of the time. And I think that you all did really, really well with that. And then the last global comment, I thought the lawyers, the folks serving as advocates were very courteous, and that is important. We can have disagreements, you can be a forceful advocate, and you can do that without getting angry or name calling or taking cheap shots or relying on underhanded tactics. I wish more members of our profession kept that in mind when they walked into the courtroom, but you all handled that excellently. And so just a couple of shout outs of folks who I thought did remarkably well. Andrew, I thought your voir dire of Rogers was incredibly effective. The goal of that voir dire is always to put that idea in the back of the juror's mind that, I can't really be sure I trust what this witness is going to say. And I think you did that very, very effectively. And I will say, as a person who, when I was in private practice, we did a products liability defense case or two, and the tone, Andrew, of your presentation was right on the money. Calm, focused on the facts, sympathetic, but really getting into the details. I thought that was really well done. Carmela, I thought that your cross of Durst was very well done. Your objections were well argued. And on the cross examination itself, I think you really stuck with it and got the points that you needed. It was your presentation that, kind of put it in my mind, at least, that, we were going to really need to look closely at the evidence on causation in this case. And then finally, Jordan, I really loved your cross of the last witness. I think it was Williams. I thought it was ice cold, and you were unfazed when he tried to knock you off your spot. So I was impressed by that. And I think most importantly, also, Jordan, when you worked your way through the technical issue that you had with sound, I think you handled that in a very poised way. A very brief story of mine. The very first closing I gave in front of a federal jury, I had a clicker for a PowerPoint presentation, and the clicker conked out about 2/3 of the way through the closing. And so we had to scramble around and apologize to the jury for the technical glitch and get right back into it. But I think that's the most important thing to keep in mind in work like this, like what Mike Tyson says, everybody has a plan until they get punched in the mouth. Keeping on your toes and moving forward and making your presentation, even when things don't go exactly according to plan, is the most important thing. And I think that was a wonderful example of that you showed today. So again, really well done, everybody. Thank you again for the wonderful presentation.
My name is Barry Schwartz, and I have so much to say, but I'm going to be brief. I want to respect your time. I'm a Denver County Court judge. I used to be, I did civil practice for a little bit over 25 years, and then I was a federal public defender. And now I'm a criminal court judge. And I just want to say what an this is like an incredibly esteemed group of judges here, and I am grateful to be part of it. One of the things I want to talk about is, I'm just going to bounce around, I'll just be honest with you, is the hearsay stuff. I agree with what the other judges said, but the truth is in this competition, everything comes in. So notwithstanding, don't take to heart my substantive rulings on your hearsay objections, because I was going to let all that stuff in for purposes of the competition. So I'm going to just bounce around, and some people I'll talk more about or two. So it's not a reflection on any of you. One of the things that as a criminal defense lawyer, as the lieutenant knows, and as a plaintiff's lawyer, as I've been, you have to personalize your client. One of the things that nobody did was say my client. I personally think that's my pet peeve, is the words my client, because it's not about you, it's about them. So there's a sort of a corollary there, and that is, Ms. Ryan, in your opening, you say we the plaintiffs. You started with we the plaintiffs. It's not we the plaintiffs. It is, Joe Smith, the plaintiff, because it is all about that person. So that's a small point. You have to humanize them, because the other side's going to dehumanize your individual client. They're going to call them the plaintiff or the defendant. They're not going to use their name. You have to use their name. And then you ended your opening with find them liable. And that you don't want them to be found liable. You want them to award, to make them pay for the life they destroyed. And so humanize it in that sense. Mr. Markle, your opening was really good. Ms. Ryan, I totally agree with Mr. Scarpato. It's all about handling adversity, and you handled adversity really well. His story is perfect. One of the things, and this is especially true for female lawyers, is that there's an expectation that you take on a persona that's not yours. And I couldn't say it more strongly than to say to all of you, but especially the young women, be yourself. Don't adopt a character. Don't fake rage if you don't have rage. You have to be yourself, because you're not credible if you're not. Ms. Ryan, I want to return to you. And so, Ms. Dino, on your cross-examination of Weirs, you had a conversational style. And I think that's immensely helpful. I think that the rage part is fun, but it only goes so far. A conversational style, because people pay attention to a conversation, I find personally as a fact finder to be very, very helpful and effective. So you did a really nice job there. Ms. Ryan, your redirect was excellent. It's short and sweet. The last word, a plaintiff and also the prosecution of criminal cases get the last word, of the proponent of a witness, and there's nothing more valuable. And so, Ms. Ryan, you cleaned up the mess. The purpose for a redirect is to clean up the mess and move on. And you did that beautifully, short and sweet. And that's the way redirect should be. Boy, let's see. And Ms. Longi, you did the same thing. I want to speak to Mr. Markle about his voir dire. The purpose of voir dire isn't always to get someone not to testify. It's to give them a little bit of a bloody nose. And I think a couple of our other judges, to give them a preemptive bloody nose. And you don't get to do that very often. And so I think it's a wasted opportunity not to take advantage of voir dire. But it's also ineffective to overdo it. I thought that the voir dires that were done, all of the voir dires, or at least I think 2, were outstanding, because you let the person come on in. You let them, you didn't even object, I think, but you did. You gave them a little bit of a bloody nose. And I thought that was very effective. One thing that I thought was really good is that testimony, in my perspective, and others might disagree, is like a balloon. And that is that one good question on cross can pop it. You don't have to beat up on every single thing that somebody says as part of cross. You need to undermine significantly one thing they've done, or undermine their credibility. And some of the other scoring judges might disagree, but you don't have to beat everything up. And so one of the things that Mr. Markle established was that the other chemicals weren't tested for. And I think that that one bit of questioning was extremely effective. And it sort of was an excellent defense to an entire line of questions from the other side. What a number of you did, and I would love to have heard from the other judges on this, is there's different approaches to questioning witnesses. Some call it the I don't know, the box or the room approach where you talk about one thing and then you close that door and you say, all right, let's turn to this subject. Some people like that approach. I love it. I think it, as a judge, it helps me organize my thinking. And you guys all did that very well. Let's move on to this. And so those of you who tried to, it sort of compartmentalizes things in the fact finder's mind, and it's very effective. And you guys did that well. Ms. Combe, you had a very short and sweet redirect yourself that I really appreciated. You also had an excellent voir dire. Let's see. Ms. Carbone, we had a fight over some piece of evidence, and I did some arbitrary ruling. But what you realized at some point was, rather than fighting about whether or not to ask a question, just re-ask it. Why go to the mat on whether something suggests something, or just say, I'll re-ask. And that shows power and authority and persuasiveness. One of the things that that people tend to do, and I have young lawyers in my courtroom, and you guys are every bit as good as the young lawyers in my courtroom, is Ms. Longi, you cross-examined the CEO about the email, and to try to get her to buy into it. And of course, she's not going to do that. She denies that email, period, full stop, end of story. So rather than just asking questions that you're not going to get a good answer to, just save it for your closing. That was out there. That was bad information. You're more effective when you can argue about it than when you can argue without anybody hearing back from anybody. Then you can argue it in closing. And so that was really effective. Two other sort of universal comments is that the critical point, and Mr. Scarpato touched on this, as did the lieutenant, is that, and no, actually, I take that back. Ms. Whitcup did. On direct, you make the witness the star. So you just blend into the woodwork and you ask these open-ended questions, and you want all eyes focused on your witness. They're the star. But on cross, it's a fight for attention, and it's a war to have people to have eyes. And I think all of you did a pretty good job of asking open-ended questions on direct. And then I would have appreciated more, like a better mix of leading questions on cross. But all of you were effective in letting your witness, the witnesses you proposed, be the stars. You might want to think about, there was Ms. Rind avoided redirect. She chose not to redirect. And I wonder, I think that redirect is like picking low-hanging fruit. So I'd love to hear what the other judges think about whether or not it's ever a good idea not to redirect when you have the right. Finally, with respect to specifics, Ms. Ryan, you returned to your theme, and I always enjoy when people have a theme in opening. It doesn't have to be a complicated theme. It can be just a few words. And yours was, you just returned to your very simple theme. They knew the risks and they sold it anyway, period. That's your theme, and I loved it. Whenever you guys got away from your notes, you were better. Ms. Dino, I don't know that you used notes or anything like that, but it didn't appear that you did on your closing, and that made it a very effective closing. All right. One thing else I want to say in the broader perspective is that this is really, I want to tell the judges how much I appreciate it. I love doing this. I've done it for years. You guys are now involved in in civic engagement, and you're the people that are going to vote, and you're the people that are going to run for office, and you're the people that are going to read the newspapers. And I can't tell you how important it is to me that you do that, and how grateful I am that you're involved in something like this. Finally, as Mr. Scarpato pointed out, that courtesy is the way to go. It's easy to want to be pissed and to show your rage at the other side and all that, especially in criminal cases. And I bet Lieutenant Malone has a million examples of it. But what matters is courtesy. And for me as a judge, when people act pissed off when it's not real, or when they're rude to one another, that hurts. It always hurts. Even when you feel like it's righteous indignation, it hurts you. So that's an immense amount of information. I hope that what we've told you helped. Again, I just want to repeat what a great group you were and what an amazing group of judges there were. So thank you. Good luck with the next round. Anybody else want anything to add, or does anybody have a question for any of the judges? I mean, now's a great opportunity. I know you want to get moving, but if any of you have any questions for the judges.
I was just gonna address the lieutenant really quickly. I'm actually super interested in being a JAG. I'm a junior in high school right now. I know Dirk also. We're both going, like, he's going to the ROTC program. I'm interested in it. Do you have any like advice, overwhelming just interests, I guess?
Yeah, I absolutely love it. I think it's the greatest job in the world. I've actually worked for the Colorado or the Attorney General for the state of Colorado, as well as for the U.S. Attorney's Office in Denver. And I like my job even more. No, offense to Mr. Scarpato. I get to move around all the time. I get to constantly do different work. I get to wear a uniform every day and work with, I think, the greatest group of people. Even the ones who are accused of crimes are individuals who decided to do a very unique and very admirable thing. And they took an oath to support and defend the Constitution of the United States against all enemies, foreign and domestic. Absolutely love the training that I have received. I think nothing will prepare you for life and being an attorney better than the Navy JAG Corps. So it was always my dream job. I've gotten to go to sea. I've gotten to come here to Pearl Harbor, Hawaii. Have been to Newport, Rhode Island. Have worked with some really, truly incredible people. So that's my, 40,000 foot overview of why I love my job. And I would strongly encourage anyone to consider the JAG Corps or consider military service or service to their nation. That I'm an attorney, I love my job, and I think there's lots of people who are doing some really incredible work in all of the branches, whether they're lawyers, whether they're doctors, whether they're soldiers, sailors, pilots. I think it's a absolute blast. I'm happy to answer any specific questions you have either right now or because I know you have other things to get on. I'm happy to share my email if you want to contact me anytime later on in the future.
Let's do that. I think that he has great advice that he can offer you specifically at your age.
Yeah, thank you so much. That would be incredible.
Certainly. I just dropped my email in the chat box. Everybody should be able to have it. More than happy if anybody wants to reach out to me about the Navy, being an attorney, law school, Navy JAG.
Awesome. Well done.
Awesome. Thank you guys so much. We really appreciate it.
Thank you all. I really appreciate the other judges. You guys are amazing. Mr. Scarpato, we'll see you at East, I hope.
You
Lieutenant.
will. I just heard from Matt.
Sorry.
Good.
I was also going to say, as soon as I saw the uniform, I was really excited that you were in our Zoom. As Leah said, I'm actually going to be a Marine option in ROTC, actually at Vanderbilt next year, which I'm super excited about. I'm probably not going to be a lawyer, unfortunately. I'm probably going to go into infantry because that's, kind of the gold standard of the Marine Corps. But it was just really awesome to see a JAG on our mock trial. And I just wanted to say that. Thank you for your service and all that.
Congratulations to you. I work very, very closely with the Marines. We have a partially consolidated JAG Corps. So currently trying a case that my first chair is a Marine officer stationed in Okinawa. Excellent guy. Marines I have the utmost respect for and also have a lot of fun with. For your information, they're one of the few JAG Corps that treat their JAGs as also combat officers. So I will always be an attorney. They will never ask me to, drive a ship or anything like that. Marines and actually the Coast Guard are the two that their lawyers are also cross-trained and expected to serve in non-legal positions over the course of their career. So I'm not trying to pitch you on, consider being a JAG, but all of the Marine JAGs that I know spend a very significant amount of their career doing non-legal things. So just a thought to put in the back of your mind. If you do want to do law school and serve in an infantry unit simultaneously, the Marines will actually let you do that.
That's really cool. I actually didn't know that. I did know every Marine is a rifleman, but I didn't know that they literally yeah.
Literally, they roughly a third of their career, they're expected to do something that is not being a lawyer. Some of them do considerably more than a third of their career in a non-attorney billet.
Well, that's fantastic. Again, thank you so much just for being present. It was really cool to see that. I got to go head off to lunch, but it was an honor. Thank you.
Best of luck to you.
Yes.
Thank you, everyone. Have a great afternoon.
The next round is when?
The next round starts at
Oh, I didn't hear you.
The next round starts at 1 p.m.
At 1 p.m. I will be there. Thank you.